Thank you. I call to order this meeting of the Board of Zoning Appeals on April 20th, 2023. May I please have the roll call?
Ballard. Burrell.
Here.
McCoy.
Here.
I heard it. I heard it.
Yeah, here.
Yeah,
And Throckmorton.
here. I believe we have a set of minutes in front of us. If there are no, if there's no action beyond putting them into the record, if we have any corrections or whatever, do so now. Otherwise, I'll entertain a motion.
Motion to approve the minutes of March 23rd, 2023.
Second. We have a motion and a second. Can I have the roll call, please? Sorry, vote, please.
Burrell.
Yes.
McCoy.
Yes.
Throckmorton.
Yes.
And Ballard.
Yes.
Reports, resolutions, communications from the staff, please.
Thank you. Jackie Scanlon, Development Services Manager. We want to let you know that the last petition on the agenda tonight, AA 1423, Chris Junkin Shield Sexton Co., it will not be heard. So we are actually withdrawing that notice of violation and working with the petitioner on a resolution. And so the administrative appeal has been withdrawn. So that is why he isn't here, and that will not be heard this evening.
Are those the only reports?
I believe so. Mr. Grulich, do you have anything to report?
I do not.
Okay, thank you.
So my understanding then is the administrative appeal 1423 is completely off the docket. It's not a continuation, just to be clear.
Correct.
Thank you. We do have one petition that has been continued to May 25th, 2023. That is an administrative appeal, AA-17-22, Joe Kemp Construction, LLC, and Blackwell Construction. Again, that'll move to our next meeting. Beyond that, we will be hearing today 4 petitions. Administrative appeal AA-08-23, Leo, and I will ask, is it Pilichowski or Pilikowski? Chow, okay, Pilichowski. We have variance V-09-23, Bryn Shore Development. Administrative appeal AA-12-23, Leo Pilichowski. We have a variance V-13-23, Leo Pilichowski. Those will be what we hear today. Unless there are any errors, let me know now. No? Okay, then let's go ahead and move to the first petition, which is the administrative appeal, AA-08-23, Leo Pilichowski. We'll call you to the podium when we're ready. Go ahead and relax until we hear the report. Thank you. Staff, please.
Thank you. As mentioned, this is a request from Leo Pilichowski for a property at 2028 East 1st Street. The petitioner is here tonight to request an administrative appeal that a property owner is required to install required sidewalks and street trees, and also that a credit towards preservation of existing landscaping does not apply towards street trees. So as you mentioned, this petition site has 3 cases before us tonight. So I will go over some of the basics of that with this, and then on the subsequent petitions kind of be a little bit more expedient on this. So this is for a property at the southwest corner of East 1st Street and South High. It's zoned single-family residential, and the petitioner came forward for a building permit in 2021 to construct a new single-family residence on the property. As part of the construction of the new single-family residence, one of the requirements from the Unified Development Ordinance requires a sidewalk and street trees along the High Street frontage. The petitioner showed the required improvements along that frontage and constructed the house. The petitioner was notified by staff that those improvements were not improved, were not provided on the property. And so the petitioner has come forward with a series of requests to deal with some items related to those improvements. So the petition site was previously vacant, it was undeveloped. To the east of this, all surrounding properties are single-family residential in nature. The Binford Rogers School District or school campus is just immediately to the east of this. To the north, you have several churches and schools as well. So as I mentioned with the site plan for the new single-family residence, a sidewalk and tree plot and street trees were required along High Street. And so the petitioner is here tonight to request an administrative appeal of the staff's interpretation or application of the UDO that the petitioner is required to install those improvements. As the board is aware, with various petitions that come forward with approval, there are a variety of site improvements that are required. Those can range from landscaping to bike racks to sidewalks to any number of things. And so those are all required to be installed by a petitioner prior to occupancy for a particular building or for the site. In this particular case, the planning department does not issue recommendations of final occupancy for single-family residences. And so the petitioner has been in the building or using the residence for a while and was notified by the planning department that the required improvements along High Street needed to be installed. So as I mentioned, the petitioner is requesting the administrative appeal of the interpretation that the petitioner is required to install those improvements. So the Unified Development Ordinance in Chapter 4 outlines the situations when a sidewalk is required. As the board is probably aware from various petitions that it has heard over the years, there's very specific language in the UDO of when a sidewalk is required. That is required only along classified streets. And if there are existing facilities, then the sidewalks can be required as well. So High Street is a classified street. So the sidewalk and tree plant are required along High Street. As I mentioned, they show that on the required site plan. So the petitioner is specifically appealing that he is required to install the improvements, and instead there is a provision or a allowance in state code called the Barrett Law that allows for a community to install certain public improvements and then bill the petitioner accordingly for those improvements. However, this is not something that has been incorporated within Bloomington. We do not have anything set up within our local financial mechanisms or any of our administrative processes for other departments for them to carry forward this action and then bill a petitioner for those improvements. So that is something, the use of this mechanism is something that really is made and decided by the administration as well as other departments, whether or not we want to provide for this mechanism. This is not really something that is dictated or guided or required in any means by state code. As I mentioned, it's just an allowance that if a community wants to do this, they can. We are never obligated to do this. It's simply a possible path that a community could follow if they want to. However, the UDO does require that the property owner install any necessary site improvements. The funding for that is not something that is under the purview of the Board of Zoning Appeals. The Board of Zoning Appeals, especially the administrative appeal process, is to deal with any ambiguities in the UDO in regards to interpretations of that. However, the UDO is very clear that property owners are required to install improvements. The funding for that is not something that is carried forward through the Board of Zoning Appeals process. The petitioner is also appealing a section of the Unified Development Ordinance that deals with the preservation of existing vegetation. So in our landscaping section, there is a citation that allows for existing vegetation, trees or shrubs, if they are preserved on a property, that they may be counted for required landscaping. So we see this oftentimes in situations where you have a property where somebody is keeping a large tree or several large trees, and they have a requirement throughout the site to plant additional trees to meet our site landscaping requirements or parking lot landscaping requirements. However, the street tree provision or the street tree requirement in the Unified Development Ordinance is not requiring a certain number of trees per se, but a spatial requirement. So street trees are required every 40 feet. So we have never applied this preservation of existing vegetation towards counting as a credit for other street trees. The intent of street trees is to provide a uniform streetscape along a property, which is different than, a certain amount of trees that are required within the property itself. So the staff in our initial or interpretation did not count any of the existing vegetation, specifically the trees that were close to the street, as counting as a credit. Certainly the trees that are in the tree plot area, we count those as street trees on a 1-to-1 ratio, but there cannot be street trees more than every 40 feet. So that is what the petitioner is appealing to the Board of Zoning Appeals. So as we have consistently made present to the BZA during these administrative appeals, we do not have a findings or a recommendation. We are simply presenting the facts for the BZA for their consideration. So with that, I'm happy to answer any questions, certainly once the petitioner has a chance to give their presentation.
Thank you. I'd ask the petitioner to come forward. I'll also just outline what we're going to do, just to be clear. You will have 20 minutes to speak towards your appeal. The time that you do not use at this point will be retained, and you will have the opportunity to use that time before the end of your appeal. The second part is there will be questions and answers. We ask that you only respond to questions that are presented to you and to not interrupt. I'm going to swear you in. I'm going to ask for your name, swear you in, and then I'll have you start your presentation. Is that okay?
Yes, sir.
Thank you. So, Mr. Pilichowski, do you affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And I'm sorry, I should have asked you to have you state your name. Please state your full name for the record.
Leo Pilichowski.
Thank you. And you have 20 minutes.
Thank you. Yes, will you please put the first slide up? Thank you. Mr. Grulich explained pretty much what this is and what I'm doing. I would like to make one correction. The November 1st, the interpretation preceding the February interpretation preceding the March letter of a notice of violation was the first notice that I had that the city was going to act on a violation at this time and that there was a violation. Okay? For completeness, I've submitted a bunch in evidence, I think 80 pages. I'd like to make that part of the record, as I would like to make these slides part of the record. I don't contest that there's off-site sidewalk is required. It's required. My contest is the manner of which that sidewalk, the requirement is done, and who has to install it. I did my due diligence when we bought this lot. I talked to the planning director at the time, Tom Makuta. At that time, for particular situations, and this is one of them, one could contribute to a sidewalk fund instead of building a sidewalk on places where sidewalk wasn't needed or where for some other reason. They had just built the Clifton Side Path at that time, which actually took the place, built instead of building the sidewalk on East First Street for the school kids at the school. And it was a safer provision, the neighborhood wanted it, and they chose a more expensive but a safer provision on Clifton Side Path. My problem is the liability of building a sidewalk stub that ends mid-block at that tree and the low wall. Anybody who takes that sidewalk can't go anywhere without jaywalking, going in the street, or turning around. This is especially true of the school children at the nearby school. In fact, it's illegal in Indiana to jaywalk or to walk along that street not facing traffic. So if you walk away, you haven't met the Indiana code. I don't want the liability, and that's why I'm concerned about this sidewalk. It's not a question of expense. I have a right-of-way license, the bonding and the insurance to actually build the sidewalk. Okay, I budgeted the money that a private contractor would take to do that sidewalk. I've approached the city about this for the last 2 years before I even signed the contract for the house to tell about the Barrett's Law and what I think applied. The city and the city attorney never answered me after repeated requests to talk to me about this and at least give me an appealable determination so that I could go to the BZA and then take it to court if necessary. Okay? I have done everything I can to try to resolve this issue during the construction phase and afterward. I even took an appeal to this board last year in July that had to do with a curb that would have led to the same thing, but because the city wouldn't let me do my driveway without doing the curb, I did the curb at the same time, stupidly, and they claimed I didn't have any standing anymore, so I didn't appeal that. I've done everything I could, and the only time I got a answer in the Barrett's Law that I could appeal, other than from the city attorney who said I couldn't appeal it, was in February of this year. I immediately filed an appeal. So right now I would like to talk about the tree plot. Okay? Can you please show the second slide? Okay. The UDO clearly says that you get street trees for required landscaping. The question is, how does that apply? There are 2 types of trees in the UDO, interior trees and street trees. Street trees are required landscaping. There is no exception. It doesn't, this exception for putting together substitute for existing mature vegetation for required landscaping, there's no limit. And in fact, under the list of what you can possibly do, what trees you can do, they clearly list in the section, they list street trees. Okay. Now, I told Eric Gulich this before I submitted the site plan, before I did the building plan. It was part of my email. It was a May 9th, 2021 email. He never responded to it. Okay? Then, on my site plan, can you please show the next page, which will show the site plan, please? One more page. See in the upper right-hand corner? Existing West Walnut, et cetera, hickory trees will count as a thing. That's on the site plan. That's on the approved site plan. So when Eric didn't tell me anything about this, I assumed that was approved. Okay? And I operated under that circumstance and saved a couple of the trees on the interior that the contractor really wanted to remove because it made us, we had to store dirt off-site at the time before we could bring it back to do the backfill and the thing. That's the 2 trees, the honey locust and the walnut, just to the south of the house plot. Unfortunately, we had to remove the 100-foot tulip poplar because it was diseased and we couldn't keep it. I would have loved to have done that. Can we go back to the, okay, now, can we go back to, yeah, Eric actually approved the site plan with me, sent me an email on 7/7/2021 that we'll approve this site plan. All you gotta do is write in it, you need a 6-foot wide sidewalk, okay, concrete sidewalk. In the course of this emails, he also stated that if I built the sidewalk with a 6-foot sidewalk, I would only have 2 feet between the sidewalk and the curb. That's not a legal tree plot, so there wouldn't be any trees required in that plot. The UDO requires the trees to go outside the plot onto my own personal property at the time. That's fine. I knew that, and I actually planned on putting trees when all this issue was solved, but the requirements for the code were approved in the site plan that I could do street substitution. The text of the UDO is quite clear. There is no limit for street trees. Just as Eric pointed out, hey, area is different. If you have 35 trees per acre, you can reduce that number. Well, if I have a tree every 40 feet, or I have every 40 feet with a separation of 40, you can also reduce the number just the same way. Linear dimensions are the same as area dimensions. They're just, one's 2 dimensions, one is 1. Okay. So I believe that the code is written in such a way that you can do the substitution. If that is not what the city wants, go back to the city council and have the UDO changed. The clear text of the code says that you can substitute for any required landscaping. Street trees are required landscaping, and they're listed in the substitutions which are allowed in the code. And since the 2-foot tree plot can't have any trees, I cannot violate the UDO by not having a tree plot. Because you can't, there's no 5-foot tree plot available on the property at all. The code knows about that and puts it on the property itself. So I asked the BZ to make a finding that existing trees on site may be substituted for the required landscaping. Can we bring the slide up that talks about the manner of construction? Two more slides? That one right there, yes. This is the meat of the appeal here. The UDO considers there could be conflicts between the state code, federal code, and the city code. The UDO judges those conflicts on what's a stricter provision. Unfortunately, the state code says, tough luck, we're the state, we take, in some aspects, we take precedence over the city law. I realize that you have a hard time judging between the two at the time. And the state law clearly says if there's a specific manner in the state law to implement something, you have to use that manner rather than the municipality's manner for a home rule city, which Bloomington is. This is the requirement that a homeowner, a property owner, build a sidewalk in the off-site, in the right-of-way next to his property. The UDO requires that to get a building permit. The state law requires that if the Public Works Administrator or Commission asks you to do so. The manners are different. The UDO says, you don't build it, we'll fine you, or if you say you're not going to build it, we won't give you a building permit. The state says differently, well, if you don't want to build it, the municipality will build it and bill you according to a process. The fact is, that particular Barrett law process in the state law is actually the method that follows the U.S. Constitution for how a property owner with a building permit can be restricted or required to build off-site. Okay? The UDO here does not do that. But we're not arguing a constitutional issue here. We're arguing whether or not the city should follow the manner that's in the state law. Now, the UDO clearly states that you can judge between conflicting things based on strictness. It's my feeling that the state requirement from the Barrett law allows the city to request not only streets, but also curbs. That's stricter, because you can do more. It also allows the city to request that anybody build a sidewalk, not just new development. That's stricter. And if you want to look at it another way, if the state says, if you don't follow this manner, you can't require the property owner to build a sidewalk, that's definitely stricter too. So I'm asking the city, in this particular case, to rule that the Barrett law is actually stricter, and that in that respect, the Barrett law should take precedence over the UDO, and in a finding that I've asked for, the finding is that the BZA can recommend that, can find that, and could also find that the planning department, if they wish a sidewalk to be built, can ask the Public Works Administrator to request it from me and do so. Now, I'd like to just add something that it's going to come up a little bit later, and I just got a text about it, but I won't read it. There's a meeting tonight for an MUP, a corridor study, and actually it's the mayor and council has funded this or will fund it, a pedestrian corridor upgrade on High Street from south of Hillside to 3rd Street. They're talking about tonight. My neighbors wanted to come here tonight. They're not here because I said that they should come to that meeting. That meeting is much more important. They come here to support me. we're going to get that done anyway. The city's going to build that sidewalk anyway, probably, on my west side. So I'm going to get what I want in what I think, and I'm going to get what I really need is the sidewalk continuous from First to Maxwell. That's the reason I don't want the liability. I can't actually build a sidewalk there. But once we're going to do a whole sidewalk, that's fantastic, okay? And I will build my section right away, even if I'm not required, because the city will ask me to do it, and I'll do it. So therefore, I ask the city right now, at the board, to rule in my favor on this, okay? Because you're going to get a sidewalk anyway. And you're going to get a sidewalk without charging me $105,000 a week in fines, $5 million a year in fines, while this matter goes to the courts, and if I take it that way. Because I cannot build that sidewalk with the liability. I lose my liability insurance, will not cover it. So thank you for your time. I appreciate it.
Okay, and again, the remainder of your time can be used later on. First, it's back to the board for any questions you might have of staff or of the petitioner, so please stand by. And what I would suggest, Jackie, is let's check online first to see if our member who's joining us has a question before we ask here in chambers.
Okay, great. Autumn, do you have any questions? And you'll have to turn your video on when you speak.
Yeah, if I just sit down.
But please.
Oh, I'm just getting there.
Okay, thank you.
I just want to be crystal clear. So the main question is that he does not want to build the sidewalk at this time. And the existing trees, the trees that are there now, he wants that to be sufficient enough. Am I understanding, is there two issues here?
Is that question, Autumn, for the staff or for the petitioner?
Well, I guess for the petitioner, just to make sure I'm understanding exactly what he's wanting. I understand he doesn't want to build the sidewalk now for liability purposes, but was there also with the existing trees, does he want that to be sufficient enough?
Yeah, as in the approved site plan, I used 3 of the existing trees on the site, not all of them. They give credits for at least 9 approved, 9 trees, and I wanted those credits to take the place of the street trees. Now, I will tell you, the one reason not to do street trees is because we don't know where the sidewalk's going to be. With a 2-foot plot, the street trees are going to be my property. If they do the MUP and whatnot, the trees, and if we don't have a sidewalk, the trees can be next to the street. Okay, so we can't really do that until we solve the sidewalk issue. But I'm going to tell you right now, I'm going to put non-street trees on the interior of my lot to block it. I plan on doing that. I haven't done it yet because we have to solve the sidewalk issue before I know what the landscaping is going to be completely done. And yes, it's not that I don't want to build a sidewalk. It's that unless the sidewalk goes all the way from First to to Maxwell, it's a real liability issue and a safety issue for the school kids and everybody in that issue. That's my contingent. So thank you.
So it feels like that before the trees go in, you feel like the sidewalk needs to go in first.
No, not at all. We decide if the city has to build a sidewalk, I'm going to put street trees, the substitute trees on my property anyway. But I don't want the requirements of what kind of trees, because they're not going to be on the street anymore. They're going to be on my property and whatnot. And I wanted to solve this street tree problem by just taking the credits. And the UDO clearly states that I can take the credits. And if it's done, yeah, thank you.
Okay, I understand that. Those are my questions. Thank you.
Real quick, Mrs. McCoy, I guess I just wanted to clarify. You know, we have 3 petitions on the agenda tonight, and each kind of deal with specific separate items. So this exact petition right now, this administrative appeal case that we are hearing right now is regarding who is required to install the sidewalk and who pays for it. And the second is, are we required to count the existing trees and as a credit towards other required street trees. It's not about, where the street trees are going or are they required. It's are we required? Do we have to approve a credit for existing street trees to count as multiple street trees? So there are two separate topics in this exact appeal. Who pays for a sidewalk? And do we have to require or allow for a credit for these street trees to not require additional street trees to be installed? So I know it's hard to keep that separate from a lot of the information that was kind of relayed, but it's important for each petition to keep the facts separately of what exactly each administrative appeal is regarding.
Do we have a number? Because I think he said he has 3 maybe. Do we have a number of a total street trees that you're wanting him to plant?
So street trees are required, 1 for every 40 feet. I think he has approximately 120 feet of frontage.
Okay.
So 3 street trees would be required along High Street.
And he has 3 trees right now.
So as of right now, I think that there are 2 trees, and I'll just kind of go back to my site photo. There are 2 trees at the far back of the property. I'm so sorry. I need to share. So there are 2 trees, there is a clump of 3 trees at the far south end of his property. There may have been some others along the frontage, but those were all removed. So the petitioner is basically saying that, the landscaping, the preservation of existing landscaping says that we may approve the substitution or a credit of existing vegetation counting towards required landscaping. We have taken the position that we are not approving the preservation of these 3 trees to count for the entire corridor and the required trees every 40 feet.
Okay, because you're talking about the 40 feet along the road, correct?
Yeah, so a street tree is required every 40 feet.
Okay. So where the empty spot is, that's where the trees need to go.
Yeah, so there should be at least 2 more trees within that empty spot here.
Along with the sidewalk.
Along with the sidewalk. So in my conversations with Mr. Polichowski from the early on, we had talked about preserving existing trees, having those count as existing street trees, and the location of the sidewalk. We were happy to work with him to keep existing trees if those wanted to be used as street trees. And that was something that we were going to deal with when it came time for the sidewalk installation, if he was keeping existing trees or if he was planting new ones, or kind of how that was going to play out.
Okay. Thank you.
To you, Autumn, if we'll keep our eye on you. Any questions here in the chambers, please?
Quick ones, one for staff, one for the petitioner. Can Jackie or someone speak to this MUP you're referring to in terms of the city's plans to extend the sidewalk from Maxwell to, you say, 3rd? Mr. Polichowski, did you say that?
Yes.
Okay. Do we know, can you just speak to that?
Can you come to please come to the microphone.
I thought that was a staff question.
Yeah, it was. I'm sorry.
Okay, yeah.
I don't know who knows more.
Yes, the MUP is it's a website in the city it's called the Arden to 3rd Street, High Street MUP. Yes, they're studying it tonight. I got a text. I haven't read it about whether they're going to prefer the east side or the west side. If I got the text, they got a preference right now, and because my wife's at that meeting, essentially. So, but I like to correct one thing I'll correct it later when I have more time. But yes, there is a plan there. And later on in the hearing, I'll show you the letter for that plan. But that's not applicable to this part of the hearing, as Eric said, and we're getting off track of them.
Right, but in the scope of whether it's done by you now or done by the city down the road, that obviously...
Okay. Well, I will be paying for it, okay? The Barrett law requires you to pay for it. I think that even if the city does it, they'll probably approach me anyway for that. But my problem is the I can't build it unless there's the sidewalk that goes south of me to connect both street, to connect first to Maxwell. And then the sidewalk won't end in the middle of the block where Busy Street is, where a low wall and a tree is, so you have to walk into the street. That's the liability issue.
Okay, so just to follow up then,
But I am going to pay for it unless they don't do an assessment over everybody for it or they don't work it out. But it looks like I will pay for it if they follow the right procedure.
sure, okay. But then the
It's
liability.
about $15,000 right now if you do a private contractor.
Okay, so you're saying, though, your liability insurance for the property you own would not cover the sidewalk once it's installed?
No, it won't cover anything that happens there because at the end. It's called the reasonable person exception to liability insurance. If a reasonable person thinks something's dangerous that you do, we don't cover it. And that they've clearly told me that. Both insurance companies have, my commercial insurance and my homeowner's insurance.
Okay.
Thank you.
Thank you.
If you could stay at to follow up to Tim's question, so there, you showed the picture of the low wall.
Yes.
Are you able to move the low wall?
That belongs to my neighbor. And it's even more complicated than that. The walnut tree there is, when you show the picture, the property line goes almost through the center of it. So is that the city's walnut tree or mine? Okay? The hickory tree to the north of that is mine. Okay? But to extend the sidewalk and to go into my property, let's say to preserve those two trees, the sidewalk will have to extend 20 feet into my property because it will destroy the root system of the other trees in that group that you saw from the picture, and it will go, more into my neighbor's property. So that wall sticks into the right-of-way, but it's grandfathered because it's been there so long, and it was before the city took the right-of-way. So it's really a complicated situation.
So then, thank you for that. That answers my question.
Yes.
And I then turn to the staff, if anyone could then talk to me a little bit more about that wall. Is that the understanding of the city, that wall can't be moved or some kind of accommodation made so that the sidewalk could extend?
So we have not looked, at the specifics of the location of a sidewalk in regards to what is happening on the adjacent property. Right now we're just kind of working through the basic fundamental steps of, a sidewalk is required. The petitioner is required to install that sidewalk. We are happy to work with him on the specifics of where that sidewalk might stub, where it might be located on their property to keep existing trees. So we kind of have to work sequentially through this order of operations. The wall, as I'm aware, and I'm trying to pull it up on Street View to get a little bit more information on it. It doesn't really look that substantial. But, like I said, we're happy to work with property owners, and we deal with this all the time of, exact locations. Yes, we understand that something might terminate at a property line. And when that adjacent property is required to install something, that wall can be removed. That'll be at their ability because it's adjacent to their property. This wall, I'm sure, has no encroachment, from the Board of Public Works or anything like that.
So what's the city's position that the petitioner is claiming it a loss of insurance or an increase in liability if they stub the sidewalk?
I'll speak to that.
Thank you.
This is Michael Brooker, city attorney. So it would be a neat trick if we could pass liability for public right-of-way along to adjacent property owners. That's just not possible. Municipalities have tried to do that many times with the history of the state, but courts have universally rejected that argument.
I'm sorry, is your microphone on? Because,
It is on.
oh, yeah, a little better. Thank you.
If you want me to start,
Please, I couldn't hear. Thank you.
it would be a really neat trick if, for all municipalities, if you could pass liability for the condition of the public right-of-way onto private property owners who are adjacent to the public right-of-way. But that's something that's simply not allowed by Indiana law. That has been something that cities have tried many times. They've passed provisions to say, look, we're going to make adjacent property owners responsible for maintenance. by making them responsible for maintenance, we've actually passed liability for injuries to persons who use the right-of-way onto those adjacent property owners, and courts have just said, no, you have not. The city is responsible for making sure its right-of-way, its sidewalks, its streets are maintained and designed in a reasonably safe condition, and if they are not, the city is liable for that. That's the city's number one claim. That's every city's number one claim, is slip and falls. And adjacent property owners simply can't be liable for it.
So you're maintaining that that argument is incorrect, that about this liability issue? He's not in jeopardy of being responsible for liability?
That is correct. That is our position. As you can tell from the staff report, obviously, we disagree quite a bit with what Mr. Pilichowski said a moment ago on a
Yeah, I
number
just
of
want
issues.
to clarify that one point, so thank you for that. Any other questions?
Yes. So my question is to staff. Is there a time limit to construct the sidewalk? Obviously, there's different issues happening in this particular location. Is there a sidewalk bond that you can put on him, put a bond on him so the sidewalk will be constructed at a certain time? I just want to know about timing, because he's not contending that he will not build the sidewalk. So what he's concerned is with the timing here, because there are not other sidewalks that will connect to it.
I'll let Eric answer that question, but I just want to clarify. He's absolutely contending that he does not want to build the sidewalk. He will pay for someone else to build it. He does not think that he does not want to be responsible for building it. So just to be clear on that point. But Eric, can you answer Flavia's main question there?
Yeah, so in terms of the timing, we had actually incorporated with this when we approved the building permit, a note to the Monroe County Building Department, to let us know before occupancy is given, because there was a sidewalk that was required adjacent to this frontage. So when we became aware that the building was occupied without that improvement, and we notified the building department and the property owner, that's what triggered the conversation and the notice of violation for when that the sidewalk needed to be installed. As we deal with various enforcement activities, we try to take into account a wide range of things. Certainly with this, we're aware that the city is going through a process right now to determine what types of pedestrian facilities might be appropriate along High Street, and the timing for that. I without speaking for the entire department, I think we're happy to be flexible to some degree to let that process play out over the next month, to figure out what side of the street things are going to be happening on. But I think there's a little bit of flexibility at staff level of when he would have to put it in, but it does need to happen soon.
So I guess I have a question to the petitioner. Just to clarify, are you going to build the sidewalk?
Okay. This appeal is that I have the option of not building the sidewalk if I'm requested by the Public Works Commissioner. Okay, that's what this appeal is about. I have that option to choose to do so or not. The reason that I would choose that option at this time is because the sidewalk doesn't connect. If the city does build a sidewalk there on that, between, let's say, south of my property to go down to Maxwell, and only builds that, okay, which I don't expect to happen. I don't think they can. I'll explain it later in the hearing, another hearing. Then it becomes my option. If the city asks me to build it, I make it would be a lot less expensive for me to build that sidewalk than for the city to contract it out. Okay, I can do it for $33,000 in materials, because we have the equipment and we have the forms. $6,000 if we hire subs to do everything. So I can't tell you the answer to the question until so Ms. Scanlon is right. I'm saying that I have the option of choosing not to do so. I can't tell you whether I'll take that option in the future.
So just to make sure, this...
But I will have to pay for it no matter what if the Public Works Commission or somebody else asks me to do so.
So this petition, you just want to exercise the right not to build?
At this time.
At this particular administrative appeal?
Or if the city wants it right now, they can build it halfway. I mean, if the city wants to stop mid-block, okay, to meet the requirement. Maybe we can, but can I bring up two other points tonight?
Wait a second. So right now, we want you to
sorry, I
answer.
thought she was
It's
finished with
okay. I want you to answer questions, but you have time to respond to anything
Thank you.
after this. And let's
you.
separate the two,
Thank you.
please. Thank you.
Jackie Scanlon, Development Services Manager. I just want to make a point, just because since we have 3 petitions of Mr. Pilichowski tonight, but they're all kind of related to the same issue and a lot of really good questions, some that may be more appropriate for the variance that we're talking, or that will inform your discussion of the variance as well. So this first one, and Eric, Mr. Grulich or Mr. Rooker can correct me if I'm wrong, this first administrative appeal is that Mr. Pilichowski is saying that that he has the right to invoke the Barrett Law and that he has the right to invoke the Barrett Law. 1, we've told him that we don't, and that he doesn't, and Mr. Rooker can speak more to that. And that 2, he has the right to substitute those plants for his street trees. So Mr. Grulich made a point, and I just want to make sure that it landed, that the UDO allows us to let people do that. It doesn't require it. So we talk about that a lot, where a shall or a may. And it says the Planning and Transportation Department may allow substitutions. And so typically, as Eric has said in the past, we have not done that for street trees, for allowed trees on site to count for street trees. Mr. Rooker may be able to explain. I just want us to stay clear to those 2 points if we can, so that to get through them. But Mr. Rooker may be able to explain our position on the Barrett Law more than I could.
Okay, that's fine. We'll come to that if needed. However, you did bring up the next question I had. I'm I'll be able to come back to you in a second.
Go ahead.
Okay. The question I had, I think, goes to Eric, which is, I want to make sure I understand the notation that was on the site plan that indicated that the trees would be accepted for substitution. That was stated by the petitioner. Could you address that? What's your reply
Yes,
to that?
absolutely. So in that site plan, there's a note about trees to be preserved, and there are 2 that are shown on the south side of the site. So when we were reviewing that, when I was reviewing that, there were other trees that he had mentioned he might be able to preserve, and I said, that's great. If you save other trees and they are within the tree plot or immediately behind the sidewalk, we can count some of those trees. But it was not something where we said, that these 3 trees or these 2 trees, because there's really only 2 trees at the south end that are even in the tree plot or close to it, would count as all of the street trees along here. It's just a notation that the sidewalk details to be determined. So that is where we were going to go into the conversation of what was actually preserved on the site, where is the sidewalk literally going to go, and are there any trees that were preserved during the construction that can count towards that requirement?
And then to the petitioner, could you clarify then, is that your understanding of the notations on the site plan?
Mr. Grulich's interpretation is not my understanding. All of our conversations with this were done in writing and email. They're all part of the evidence that I've submitted. I did not selectively quote anything when I made this presentation. Okay? The site plan was approved with that notation on it and with my earlier emails explaining that notation. Okay? There is no question. Mr. Grulich did ask me on July 7th of 2021 to modify the site plan, to add to the site plan that the sidewalk would be 6 feet in concrete, excuse me. I added that in, you can see that's a hand notation there because I was in Wisconsin at the time, didn't have my computer. Never asked me to change anything else, okay? He had the opportunity to ask me to remove that notation. He had the opportunity to tell me that it wouldn't be acceptable. None of the emails show that. Also show that. The problem is when we talk about the preserving of trees, the location of the sidewalk, preserving of that, the hickory tree and the walnut tree to the south, we did talk about that with the location of the thing. But the walnut tree is not used as the calculations for the vegetation. Only the hickory, the west walnut, and the honey locust are used. Okay? And the reason I didn't use the walnut is because I didn't know who owned it and who could count it, where it was. I knew the other trees were on my property that could be used. So it's a little more complicated than that, but the bottom line is that they approved it. No question, it's noted on the site plan and it's noted on the emails that I have, it was approved. If it was a mistake, admit it was a mistake and go on, okay? I can go out and buy the trees and plant them right away. I don't know where to plant them, but I'll plant them on my property. That's not a problem. They may have to get torn up. In fact, I just learned on my email, my text, that they probably will be in the future, but that's neither here nor there right now. And I do have some other comments to make when I have free time.
Thank you. I'm sorry, Flavia, I think you had some questions. Sorry.
You asked the question. I was going
Sorry. Are there any further questions before we go to the public for comments? So the procedure then for the petitioners, we'll go to the public for comments if there are any, and then after that, you'll have an opportunity to use the rest of your time to address any issues. Do we have no other questions? Autumn?
I do have a question.
Thank you.
There seems to be a contradiction between the petitioner's feeling of his liability with regard to the sidewalk and the attorney saying he has no liability. I need clarification on that. Which one is it? Because if his insurance company is going to not cover him if he puts that sidewalk in, then he has a problem. But the attorney says that he doesn't, that's not, I thought that's what I heard him say, that that's not true, that shouldn't be an issue for him.
Yeah, so this is, sorry, if you're ready, Mrs.
No, I'm ready. Go ahead. I'm ready.
So just to be clear, so Michael Rooker, city attorney, when a facility is installed in the public right-of-way, the municipality that's responsible for that right-of-way, whatever town, city, county is responsible for maintenance of the right-of-way, is responsible for making sure that it's maintained as a safe public way for the public's use. That means that it has to be properly maintained and properly designed to be used safely. If somebody is hurt on a sidewalk in a slip and fall or some other incident or on a street, the municipality that's responsible for the public right-of-way is liable to that person. It is not somebody else who can be held liable for the defective condition of a sidewalk or a road. There are any number of cases all throughout the long history of Indiana that state this. There is a statutory requirement that municipalities keep their right-of-way in a safe condition for public travel, and if they don't, the municipality is the party that is liable, not the adjacent property owner. It is not atypical at all for private parties to design and build public facilities within the public right-of-way, but once those public facilities are part of the municipality's inventory of spaces in the public right-of-way, which is something that happens pretty much immediately after it's installed, there is just no question about liability at that point, none whatsoever.
Okay, thank you. Any other questions before we go to the public? Autumn? Okay. Is there anyone in the public or via Zoom who would like to make comments at this time?
If you are on Zoom and would like to comment, you can raise your virtual hand or send a message to Jackie Scanlon, host.
And while we're waiting for that, just a comment, there'd be 5-minute limit to anyone who wants to speak from the public.
I do not have any notifications on Zoom.
Thank you. Then at this point, we will return to the petitioner. How much time does he have left?
6 minutes, 48 seconds.
So just short of 7 minutes, but please take this opportunity now to address any of the things up to this point that you feel need to be addressed.
I'd like to address Mr. Roker's comments. Okay. Just as I disagreed with him about standing last July, I disagree with him here. I'm not a member of any bar, but I do have experience with this thing, and my insurance company has experience. He's mainly correct that these improvements, even if they're built by adjoining property owners, when they're on public property and the city accepts them, the city is responsible. However, there's a caveat. I don't have the cases to cite in Indiana. There's a particular case that the insurance people cited to me. But it doesn't matter whether there's a case or not, what the insurance companies want to do. But here's the problem. There's two problems. Mr. Roker says that the city's responsible for maintaining it, but they pass that maintaining duty onto the adjoining property owner. If the adjoining property owner doesn't maintain the property correctly, let's say there's a crack and they don't level it correctly, then they were the one who did the repair work to do to fix the crack. Maybe the city didn't get yet to look at it and approve it. Somebody gets hurt. The city's going to get sued and the homeowner's going to get sued, no question. On these types of lawsuits, the expense is not just the payout if the lawsuit's won or lost. It's the expense of actually trying the cases and handling the cases. Okay? And that's an important point to make. Also, in this particular case, the responsibility for this sidewalk in the city, if the city built it, they'd have to meet the PROAG, ADA, NDOT, and NDOT's Indiana Design Manual guidelines, recommendations, best practices. The design manual clearly states that when you work on a sidewalk and you do it, the recommended best practice, and this is what you're going to get hit on, is that the sidewalk goes to logical termini. In this case, it would have to go between the two intersections. It can't stop mid-block. Okay, now, we can talk more about this later at the other hearings, but that practice means that mid-block thing is dangerous. What my insurance company would says to me has nothing to do with who has responsibility. They use the reasonable person hypothesis, that if I do something that's dangerous, and that a reasonable person would think is dangerous, it's an exception to the insurance policy. And I believe Mr. Roker can agree that those exceptions do exist, and that exception does exist in the liability of almost all liability insurance policies, called reasonable person. For my commercial insurance, I'll tell you right now, they'll cancel the insurance. Okay, and we're going to let them do it. For my liability insurance, that reasonable insurance has been explained to me the same way. If I build something that can be thought of as by a reasonable person as dangerous, okay, whether or not to determine whose responsibility and to take care of this case is expensive, they don't want to do it. And so that's my problem. And so it's a complicated situation, and I'm sorry I don't have the particular case I want to talk to about a shopping center building a sidewalk that was obviously dangerous and is responsible for that sidewalk, even if it's on the city property. I don't have that case right now in front of me. I apologize. And I think that's all I have to do tonight. I have some news about the MUP, but it's not particular to this case. I would, except to say that if it's built as proposed right now, any sidewalk that's built would have to be removed. Thank you.
I'm sorry, thank you. And at this point, we can go one of two ways, which is we can have additional questions or comments, or we could entertain a motion, and then we will have time for comments or questions following a motion. It's to the board.
Can you, this is for Mr. Rooker, can you explain the Barrett Law and why we don't practice the Barrett Law in Bloomington?
Sure, I'm happy to do my best to explain what the Barrett Law is. If you wanted to understand why the Barrett Law is not used as a particular funding mechanism in Bloomington for public improvements that are in the public right-of-way, that sort of question would probably be better directed to the City Council or the Board of Public Works, as they are the bodies that would have to approve that sort of funding mechanism for public improvements. But I think Eric summarized it correctly. The Barrett Law is one way to fund public improvements where a municipality would adopt the Barrett Law and then build public improvements out and then assign, based on a certain amount of street frontage, a liability. I say liability, I shouldn't use that word in the context of this case, but they would charge back the cost of that to property owners over time potentially, so the various people who would have frontage and would benefit from that particular public improvement. This is not mandatory, contrary to what you see in some of the submissions from Mr. Pilichowski. One of the things he said is that this is the only manner in which a municipality may request an abutting property owner to construct an off-site sidewalk. That is not the case. To the extent that this board thinks that we should be debating an interpretation of the Barrett Law and whether or not that is in fact the exclusive mechanism for funding an off-site improvement like this. That's probably something that would more appropriately be sorted out through a declaratory judgment in front of a judge or the Court of Appeals or the Indiana Supreme Court in terms of interpreting the exclusive and mandatory nature of that funding provision. I will tell you that there are no municipalities in Indiana who are treating the Barrett Law as a mandatory and exclusive funding mechanism for public improvements in the right-of-way. We get things built in the right-of-way through all sorts of different means. The Barrett Law is not the only one. In fact, we don't use it at all here. So.
Thank you. Are there any other questions before we entertain a motion? Autumn?
I don't think I have any questions right now. I don't think so.
Okay, well, even after the motion, you have an opportunity to ask a question. At this point, I'll look to the board for a motion. And again, the motion would be to approve the administrative appeal or simply to deny the administrative appeal. That's what we're being asked tonight on this first action. I'm sorry, not now. We're past that. Procedural issue, yes. What's your question?
There's actually two parts to this appeal. One has the trees.
Understood. One has the trees and one has the sidewalk.
They should be separate.
Well, it's up to the board to decide whether we want
I'm
to.
suggesting that it's better to do it separate.
I understand. Procedural question you're asking me is, yes, we understand that we can do that. Thank you.
I'll just go ahead and make a motion so we can just continue discussion, but I'll move that the case AA-08-23, the administrative appeal be denied.
I have a motion. Do I have a second?
I second it.
We have a motion and a second. At this point, we have an opportunity for further discussion or explanations if you would so choose.
So I guess this is really, a question in terms of the actual numbers behind what the cost is going to be. So I guess I'm addressing this to you, Mr. Pilachowski. You're saying you'll pay for it no matter what, but really, am I interpreting this right? When I think what you're saying is, but I want to outsource it to the city to do it. Now, that has to be a pretty big cost difference, I would think. Yes.
I budgeted $15,000 for the sidewalk.
Okay.
At the time I budgeted, that was the cost, if the city went to, it was the cost, basically the square foot price that one of the contractors who normally bids on these for the city takes. Okay, it was $14.50 a square foot. I used $15 a square foot. There's 1,080 square feet. That's $15,000. Okay, I budgeted that. So that's the cost of doing the sidewalk. Okay, if you go to a private contractor. The cost of materials is a little over $3,000. If you do it yourself, my cost of if I subbed out the flat work and the building the forms, and even subbed out using my equipment to do the stuff, it's about $6,000 if we do it ourselves. And I have the license to do that. So I'm willing to pay the premium to do the other way, not to have to build it. That's what I'm pointing out to you, okay? That's basically the numbers that are right now. They may have gone up from the $15,000, but I will tell you the two numbers that I have are recent. I have the material costs and the labor costs.
Thank you.
Thanks.
Any other comments or questions from the board before we call the question?
Yes, I have something. I'm curious about the sidewalk to Maxwell. He made a good point, and it forces people out into the street at that point. And I'm still concerned with that part of it. Is building this, is that not going to really be an issue, and where do people go? It's not really been talked about. There's just nowhere for them to go except for the street.
So I don't know if it's appropriate at this point in time. I'm not sure, but it seems like the talk needs to be about continuing the entire sidewalk for safety. That seems to, for me, safety needs to be the most important thing. And if it's right at a school and where people are walking all the time, where are they going to go but the street, or I guess in someone's yard
It
to
sounds
walk?
like that's a question for the staff. Would you like them to respond? It sounds like that's a question for the staff. Would you like them to respond?
Oh, I'm sorry. Yeah, yes, I'm sorry. Yes.
Sure. Oh, there's Eric. Go ahead, Mr. Grulich.
Yeah, so I certainly understand that question. It feels like that might be most germane to the last petition for the variance, which would go into the criteria of whether or not a sidewalk would be required. But to get to what you're kind of getting at, within the city of Bloomington, as I mentioned at the beginning of the presentation, there are site improvements that are required on properties all the time when they develop. We encounter this situation all the time where you have an isolated property that develops and they're required to put in a sidewalk. They do it property line to property line. It may not connect to something on either end, but we get those improvements when they're required, when a property develops and they're required to do that. So it's certainly not unusual, for a sidewalk to stub at a property line. You look at a corridor, people are walking in the street or they're walking on the grass now. So providing a sidewalk at least gives them a safer place to walk for a better portion of a street.
And I would concur with that statement from Eric. We see a lot of sidewalk issues in front of this board, and it really does come down to the fact that there is no sidewalk there now, so it's inherently based on that question, it's unsafe. So do you err on the side of having no sidewalk at all that provides this suggested safety while they're on the sidewalk, or do you just say, we're not going to have anything, let them continue to walk in the street? So it is an issue that we've dealt with many times. I'm just saying that there is no precedent, so I don't want to suggest that, but I'm saying that your question is valid. It comes up a lot. But both the question of does it not create a safety hazard also then has the other side that we understand, which is does it not also provide some additional safety that wasn't there before? So that's a really valid question that you have, that you just simply have to make up your mind as to which side that you feel.
Yeah, and I would just like to, hope that maybe someday it can be extended to Maxwell so it's an even safer sidewalk, especially since it's around a school. So I better understand. But yeah, it seems like it would just be better to go all the way to Maxwell, kind of an all or nothing maybe, but I do understand now this is a start. It would be a start, I guess, to continuing a sidewalk all the way to Maxwell.
Yes, and I just want to make sure I reiterate that that's a valid concern, and it is an issue we see a lot, and it is a matter of stepping stones, so to speak, one, then the next, and the next, depending on how the development occurs.
And then secondly, it's always been my understanding, like even at my house, we're required to make sure the snow is, off the sidewalk, that we are liable for the sidewalks in front of our homes, and so that's always been my understanding. So now I'm kind of thinking that maybe we're not, but I've always been told I'm responsible for the sidewalk in front of my house. And so we are responsible for that, correct?
And that question would go again here, please.
To the attorney.
Sure, I'm happy to address this. This is where I'll offer as complete an explanation as I can. So if you do not shovel your sidewalk during a snow event, the city's recourse is to send you a notice of violation and fine you for violating the municipal code. If there is ice on your sidewalk that should have been dealt with and it has lingered for days and days and days and created a dangerous condition, and somebody slips on that ice and breaks their leg because the sidewalk was dangerous, as an adjacent property owner, you cannot be liable to that third party, the injured person. Only the city can be liable. So we can fine you and say, you should have shoveled your sidewalk and gotten the ice off of it, you should have put some salt down. But what we can't do is transfer liability for injuries to third parties from the city to you. It is ultimately and fundamentally our responsibility to make sure that the public ways are maintained in a safe way. So there are a million cases that say this, quoting from one. You know, a municipality has a common law duty to exercise reasonable care and diligence to keep its streets and sidewalks in a reasonably safe condition for travel. An ordinance that requires an abutting property owner to maintain the sidewalk in a safe way, either to fix it when it's in a poorly maintained condition because a tree root has pushed up a portion of the sidewalk or there's ice on it, that doesn't transfer liability. It simply gives the city the ability to fine a property owner who refuses to put that sidewalk back into the condition the city would prefer it was in. I know that that's sort of a nuanced distinction, but do you sort of understand what I'm describing there?
Right, right. And is the petitioner more or less liable through his insurance company if he builds a sidewalk or if the city builds a sidewalk? Does it matter to his insurance company, Mr. Petitioner? Does he?
Yes, you can step forward and answer that question.
The insurance companies can make their own decisions, okay? In this case, what I've been told, and I've looked at it for several years at this, is that they would call an exception on my homeowner's policy as a real person exception. It's written in the policy, they would call that, they would do that exception. Whether or not, and they pointed out to an Indiana law court case that I don't remember. So whether the city accepts your liability or not, the insurance company still is worried. I'm worried about it because I have done land use planning for many years and represent people in land use stuff and in civil engineering and these things and matters like this. So I have a knowledge of what's going to happen, and so that makes me my insurance company thinks I'm even more responsible. So we have an argument. If the city thinks they have it, that's fine. I'm just saying what my liability is, what I think my liability is, and what my contract or my insurance thinks it is. Okay, and that's why I didn't want to build it in the certain situation that we have. And what the insurance company...
If you build it, are you more liable than if the city builds it?
I won't be liable at all. I will not be liable at all. I will not be liable at all if the city built it, because I would not be responsible for that. But the problem with my insurance company, I want to explain this, the problem with the insurance company is there's no sidewalk there now, and they don't care about that. Okay, whether it's dangerous to walk on the street. No one walks there anyway. What they care about is if somebody walks on that sidewalk and gets to the end of that sidewalk and doesn't turn around and come back. Then they go into the street. And more people will be into the street, jaywalking or whatnot, if the sidewalk ends in the middle of the block, than if there's no start to get to that sidewalk from First Street, which means there's no sidewalk there, because people just cross the street and walk on the other side. But now they don't know the sidewalk stops. Okay? It's actually 180 feet, and I require 5 trees. But the point is and it's nuanced. I agree, but I don't get to make some of those decisions about my liability insurance. I get to make decisions about myself, and I think it's dangerous. And the liability people can make their own decisions. I think that it's dangerous myself.
Thank you.
Thank you, and I'm sorry.
Thank you.
Okay.
I appreciate it. Any other comments or questions from the board?
I think just real quick, I mean, part of my motion here is, one, defaulting to Mr. Rourke in terms of the law itself and what it states and the clarity you provided, so I appreciate you doing that. To the petitioner, I would just say, maybe shop around for a different insurance company. Like if this, and you don't have to respond to it, I'm just saying, I think if that's what you're stuck on, I think there's other options out there, because we have seen several of these cases. We continue to see these. The UDO, the overall arching vision is connectivity in neighborhoods. This is going to be a prime area to be connected. So it's kind of like the chicken or the egg, and you're going in circles with it. So this was the requirement. Setting a new precedent is, to me, like that's opening a can of worms too, so everybody who comes wants a sidewalk variance, or they're going to say, no, I'm going to put this on the city. Like that's too much of a slippery slope, because we've done this. People have followed through. They've built on new sites. They put in stub sidewalks, and they're fine. And they're covered by the city in terms of protection by the law of any kind of liability. So I think that's, at least for me, it's pretty clear on why I'm going to vote for a denial of this. Thank you.
If we have no further comments or questions from the board, we do have a motion in front of the board for action. It is to deny the appeal that the property owner is required to install required sidewalks and street trees, and that the credit toward preservation of existing landscape does not apply towards the street trees. I'm sorry, that was the request, and So we are voting to deny the administrative appeal that would say that that's not going to be required. If there's no further comments or questions, we're going to call the question and take a vote, please. Again, a yes vote is to deny the administrative appeal. A no vote is to deny the motion and then go forward with another motion.
All right, McCoy.
Just need you to help me understand this a little bit. So if we deny it, then he's going to be responsible for the trees and the sidewalk, correct?
If you deny it, oh, sorry, you can go ahead, Mr. Ricker.
Yeah, so there are some, as staff has pointed out a couple of times, there are two other appeals, or excuse me, two other
Right.
matters on the docket with Mr. Pilichowski.
Right.
This would simply be, a yes vote is to deny his appeal. So that would mean that his interpretation of the UDO regarding that he is required to design and build the sidewalk is denied, and then that the credit towards street trees, the credit of trees and other parts of the property would not count towards street trees. Sorry, I'm getting mixed up as I'm speaking. Did you follow all that?
Kind of, because please understand, this is the first time I've set in on this, so I just need help a little bit with the language.
Yeah, you're doing great.
So thank you for having patience and bearing with me on this. I appreciate that. So that's just what I need help with. So, so then
Just to
Go
restate
ahead.
then, so this, a yes vote is to deny this particular administrative appeal.
So if it's yes, then you're denying, and then he's responsible for both of them.
What we're voting on is the denial of the argument that, that he's not required to install the sidewalks and the trees.
Sorry.
So
I wanna
the
be-
request was, the petitioner is requesting an appeal that the property owner is required to install required sidewalks and street trees. And the
Right,
credit
he
toward,
doesn't want to do that. He doesn't want to do either one of them.
right, so.
And we're saying he has to.
If you vote yes to the administrative appeal, to the motion, then you will be saying, yes, he has to do that.
Okay, so you will be, this is the final, Jackie Scanlon, Development Services Manager, this is the final petition tonight specifically about the street trees. So that will close the book on that conversation, no matter what the vote happens here. The final petition for Mr. Pilichowski tonight is, he is requesting a determinate sidewalk variance, which would allow him to not build the sidewalk for some amount of time based on the discussion here. So the question about whether or not he'll have to build the sidewalk isn't being finally answered with this vote. Well, the thing that's being answered is whether or not his interpretation of the Barrett Law is, whether or not you all are agreeing that he is correct with that, and saying that the description that Mr. Rooker has described is incorrect. Am I getting it?
Yeah,
Eric?
to be a little more
Yeah,
clear.
so his appeal for the Barrett Law is simply strictly related to who pays for it. So denying this means that he has to pay for it. As Mrs. Scanlon mentioned, we will discuss with the last variance whether or not a sidewalk is required or not. This administrative appeal is simply who pays for it, and we are saying that the Barrett Law does not mandate the city to pay for it, and that he would have to pay for it if it's decided later that a sidewalk is required.
Okay, I understand. So I agree, yes, on the trees.
Well, Autumn, on this, you would have to just simply give a yes or no vote on the motion. We can't separate it out on this motion. So the yes vote would be to deny the administrative appeal, the whole thing.
So to deny his appeal. So a yes vote is to deny his appeal
Correct.
on both things. His appeal on both things. Yes.
Throckmorton.
No.
Yes.
Ballard.
Yes.
Burrell.
Yes.
The administrative appeal has been denied. One second. All right. Move on to the next motion. Let me get my notes in front of me. The next item in front of the board is a variance. It's V-09-23 Bryn Shore Development. May we have a staff report, please?
Yes, I'm Gabriel Holbrow, zoning planner for the city of Bloomington. I have some slides to pull up, so let me do that.
Could you also please speak more directly into the microphone? It's a little
Yes.
difficult to hear you. Thank you.
Do you need me to repeat it? Well,
Yeah, let's start from the top. with
the only
microphone. Thank you.
important part from my point of view is that my name is Gabriel Holbrow. I'm the zoning planner for the city of Bloomington. Okay. That is not what I wanted to show, I think. Please bear with me here. Okay, here we go. This is a petition for variances related to the core building, which is located, it's an existing historic structure located at the northwest corner of South Rogers Street and West First Street. You could also think of it as the southeast corner of the former hospital site, what we're calling Hopewell. I want to leave it to the petitioner's representatives who are here today to describe the project more in detail, but I'll just go over some overview. So the site that we're considering for these variances is a portion of an existing parcel which is planned to be subdivided. This portion is going to be bounded by Rogers Street and First Street. And then there's a proposed new Jackson Street, which will be on its west side, and then a proposed new alley, which will be on its north side. It's roughly where that red rectangle is shown on the screen. The area will be approximately 0.85 acres, give or take a little bit, depending on how that exactly shakes out in the subdivision. It's zoned mixed-use medium-scale MM, and it's within the transform redevelopment overlay that was created for the Hopewell district. In the comprehensive plan, it's mixed urban residential future land use area, and the existing land use it's vacant. As you've probably seen if you've gone by, it's a bit of a, not construction, but destruction site at the moment. The core building is being preserved, and by the time there's construction on anything that is allowed to go forward after variances tonight, it'll be a clear site with the core building and then an addition built onto it. So this is just to give you, to refresh your memory of this site. Hopefully you know about this site from walking by, driving by. This is the core building. I took this from Google Street View. This is from First Street, looking up the main building you see there is the core building. Behind it, you can see some of the old hospital buildings which do not exist right now. So it's a little bit up a hill from First Street and from Rogers. This is a rendering of more or less from the same direction as that street view. There's the existing core building in the front and then the proposed addition in the back. The proposal is to have, develop it as all residential, all affordable, 38 units. This is a site plan. I think we'll come back to it as we talk about some of the variances. But here on the right is the west, that's Roger Street to the bottom. South, that's First Street. To the left, west, is the new proposed Jackson Street. To the north is the alley. And you can see sort of in the middle is the existing core building, and then the part of that roughly H-shaped building is the new proposed addition. So I'd like to do this a little bit backwards, if that's okay, in that we have nine requested variances, and I'd like to start with the recommended findings according to the criteria that apply to all 9 variances. Do that, just go over that first, and then go back to each one, explain what the variance is, or touch on what the variance is, and the specific recommended findings for that one, and go through all 9. That's a lot. We've already been here for a while, so I want to be thorough but quick. If there's anything that you want more information on and you feel like I went too fast through, please ask during the question time so that we can go over it. So with that, the first criterion, as you know, for variances is that the approval will not be injurious to the public health, safety, morals, and general welfare of the community. Staff's proposed finding is that it will not be injurious. And the reason is, for each of the UDO standards that the petition is requesting relief from, the proposed project achieves or addresses the goals and purpose of that standard by other means. And we'll go through how each of them achieves that. So that's the staff's proposed finding for it's not injurious. The second criterion, the use and value of the area adjacent to the property, will not be affected in a substantially adverse manner. Staff's recommended finding is that it will not result in substantial adverse effects. None of the requested variance will limit the current use or future redevelopment of any of the surrounding properties. This one doesn't have detail for each of them because it just simply, staff's recommendation is a finding that it is simply true for all of the requested variances. The third criterion, that the strict application of the terms of the UDO will result in practical difficulties in the use of the property, that the practical difficulties are peculiar to the property, and that the variance will relieve those practical difficulties. So overall, the existing core building on the site and its designation as a local historic district, which includes the requirement that any addition or modification of the building be appropriate to the historic context, that situation means that there is practical difficulty in the use of the property. So the layout, configuration, and location of the existing historic building and the topography of the site place practical limits on what uses and designs are feasible. Strict application of the UDO results in practical difficulties in the use of the property, including practical difficulties for the specific use and site design that the petitioner has proposed. So let's back up again and go to the first variance. So these are numbered. These numbers are not significant or legally binding in any way. We just number that way so if we're talking about it, we can know what we're talking about. So if you want to call it something other than variance 1, that's totally okay, as long as we know what we're all talking about. The first one has to do with the front parking setback. So how far does parking have to be set back from a street? What's required in the MM district is that parking be 20 feet behind the primary structure's front building wall. What's proposed is that there's parking that is 3 feet behind the front building wall adjacent to Jackson Street. And can I hop over this way? Will it let me do this? No. So I really need it on the, well, in the interest of time, what I'll do is I'll just say that. And if you want to see that in more detail on the site plan, we can go to that. I will just highlight that the materials that were in the packet, the site plan and the renderings and the elevations that were in the packet have been slightly updated. And what was approved by the Historic Preservation Commission last week is we have received that, and it's slightly different from what was in the packet. If you want to, we'll put that into the public record, and if you have any questions about it, want to look at it, we can do that as well. I will tell you that it is the petitioner's understanding and it is staff's understanding that none of the changes affect any of the variances. So all the variances are still the same. There's some changes to the facade design. So first variance, parking needs to be set back 20 feet behind the structure's front wall. It's set 3 feet behind. So the parking area is located, so why is this not injurious? Because the parking area is located in the least conspicuous rear corner of the site, allowing the building and the primary uses of the site to engage uninterrupted with the street frontage along all 3 of the adjacent streets. So it's not meeting the letter of the UDO because it's only 3 feet where it should be 20, but given the constraints on the site, is located in the least conspicuous place possible. So it's meeting the intent of the UDO. For the third criteria, the practical difficulty is found in the topography peculiar to the site. The northwest corner of the site where the parking is proposed is the only location on the site that can be made flat enough and close enough in height to the building floor level to accommodate required ADA compliant accessible parking spaces. Just want to note, it's in the staff report, these ADA spaces are not required by the UDO, but are required by the ADA according to how they're going to use the building. So in any case, it's a requirement. So this practical difficulty is related to the feasible grade of the site as well as the adjacent alley. Okay, for variance 2, the build to range in the mixed use and non-residential zoning districts in the transform redevelopment overlay. So what's required is 0 to 15 feet, meaning that the primary buildings on the site must be between 0 and 15 feet from the edge of right-of-way. What's proposed is the existing core building is approximately 92 feet from the east front property line along Rogers Street. The existing core building is also 16 feet 3 1/8 inches from the south front property line. The existing core building is where it is. It requires a variance to stay there, but meeting the variance would require moving and, practically speaking, demolishing the core building, which at the very least has not been approved by the Historic Preservation Commission. So for the first criterion, staff's proposed finding is that the core building with its existing sloping lawn and trees between the building and the street is an established urban streetscape that is peculiar to its position in Hopewell. So it's not the setback that's exactly called for, but it's not allowing the kind of suburban streetscape where buildings are set back and they don't engage with the public street at all that the building standards in the TRO are designed to prevent. So, we're not getting something that matches the exact numbers in the UDO, but it is addressing the spirit of trying to create a new urban neighborhood here in Bloomington. For the third criterion, practical difficulties found in the location of the existing core building on the site and its designation as the local historic district. So moving the core building or adding an addition in front of its eastern or southern facades would not be appropriate to the historical context. I do want to highlight in the staff report, it mentions that the right-of-way may change due to required right-of-way dedication when this parcel is subdivided. At this time, we do not know what the setbacks will end up being. Certainly, at 92 feet from Rogers Street, the core building they're never going to dedicate that much so that setback will become compliant. It's possible that the south side will become compliant due to right-of-way dedication. But in any case, in essence, literally speaking, the petition is requesting a variance for this setback and for whatever future setback is created. Practically, just sort of in essence, what they're asking for is, can the building be where it is? Can the existing building stay where it is in essence, what it's asking for. For third variance, the use-specific standards for multifamily dwellings include that ground floor dwelling units must be or cannot be located within the first 20 feet of the building facade. This has it's all residential, so ground floor units are located 0 feet behind the building facade facing Rogers Street. So the first criterion, this UDO standard is intended to provide privacy from busy roads and at the same time provide space for retail and other public-facing uses that can activate the street. And the grade difference in setback distance of the existing core building ensure that the ground floor dwelling units have adequate privacy from Rogers Street. At the same time, the existing grade difference in setback distances prevent the building from directly activating the street, even if it contained public-facing uses. For the third criterion, the proposed finding is that practical difficulty is found in the existing width of the core building and the proposed width of the proposed addition, which is designed to be compatible with the historic building. There would not be room for any ground floor dwelling units if this standard were strictly applied because the building is, there's not enough room to go back 20 feet and still have room for a dwelling unit. So effectively losing one entire floor for residential use would make the entire project infeasible. The fourth variance, also for multifamily dwellings, floor elevation in the TRO, Transform Redevelopment Overlay, that the ground floor dwelling units in the front building, ground floor dwelling units with a front building wall facing a street should be raised 2 to 5 feet above sidewalk level. What's proposed is a uniform ground floor level throughout the entire building, the historic core building and the addition, that will be 16 feet above the sidewalk along Rogers, 13.5 feet above the sidewalk on First Street, and 0 feet above the proposed sidewalk on the new extension of Jackson Street. The floor level is set by the floor level in the existing core building. So we're kind of working with what's there. For the first criterion, the existing grade difference from the sidewalk level already provides the privacy for dwelling units that this standard intends to achieve. And practical difficulty is found in the existing ground floor level of the core building that doesn't currently meet this standard. For accessibility throughout the entire proposed building, the ground floor level for both the reuse of the core building and the proposed addition is set by the existing floor level. Fifth variance, now we're getting in still use specific standards for multifamily dwellings in the TRO. Each dwelling unit shall have direct access to a balcony, patio, or porch. And what's proposed is no direct access from dwelling units to covered balconies, patios, or porches. We can see that, or I'll just zoom up here for a minute. You can see there are no porches and awnings because there are no porches or awnings on the existing core building, and the new addition is proposed to match. So, for the first criterion, this project is achieving the purpose in another way by providing communal courtyards on the north and south sides of the center of the building, which exceed the minimum area outdoor space required by this standard. They would count, actually, if each dwelling unit had direct access onto those courtyards. But because it's a multi-story building and the courtyards are just on the ground, not all the units have direct access to the courtyard, but there is access to the courtyard. For the third criterion, the practical difficulty is found in the existing facade design of the core building and its designation as a local historic district, meaning that the addition has to match or be compatible with it. Modifications to the historic facade or alternate designs for adjacent new facades that incorporate additional windows, canopies, and balconies would not be appropriate to the historic context. Okay, now we're getting into specific requirements for exterior facades that apply to all buildings in the TRO. First, upper story windows. The standard is that a minimum of 20% of the total facade area in upper stories shall contain windows, to do shorthand. And what's proposed is 16.4% on the west facade, 20.2% on the east facade, 9.8% on the north facade, and 9.6% on the south facade. I will ask the petitioner to address if any of those numbers have changed In any case, even if they have changed, we know that some of them are going to be not compliant. So I was saving the recommended findings for the end because 6 and 7 go together. Still exterior facades, windows on the ground floor, residential facades, again, it's 20%, and what they're proposing is less than that on the east and south facades. Also, on those ground floor residential facades, canopy or awnings are required, as we talked about. Sorry, not as we talked about, but there are some canopies and awnings, but it's less than the required on the west facade and the south facade. So the proposed findings for both 6 and 7 for those elements of the facades. First of all, the criteria 1, the proposed facade design honors the historic facade design of the existing core building and provides other details and design elements that avoid blank uninterrupted walls. So that's what these standards are designed to prevent, just getting a blank wall, and the design achieves that in other ways. For the third criterion, practical difficulty is found in the existing facade design of the core building and its designation as the local historic district. The same as for the variance 5, so modifications to the historic facade or alternate designs for new facades that incorporated additional windows or canopies or balconies wouldn't be appropriate to the historic context. Okay, variance 8, building floor plate maximum. In the TRO, the building is allowed to have 5,000 square feet building floor plate without incentives, 10,000 square feet with either the affordable housing incentive or the sustainable development incentive, or 15,000 square feet with both incentives. So what's proposed is a little less than 13,000 square feet with the affordable housing incentive. As an all affordable project, the whole purpose of the project will meet the affordable housing incentive, so that's a given, but they're a little over what that limit would be. For the first criterion, the design of the building into 2 identifiable wings, the historic core building and the new addition, with 2 central courtyards, breaks up the massing of the building and avoids creating an impression of an imposing monolith beyond human scale. So even though the floor plate is more than the maximum, they're using the building design to achieve, to avoid the harm to the urban landscape that a giant building could cause, and that this standard is trying to avoid. For the third criterion, practical difficulty is found in the layout, configuration, and location of the existing historic building and the topography of the site. In theory, the addition to the building could be achieved with a smaller floor plate. However, that would require that the building be taller and out of scale with the existing historic structure. In deference to the historic structure, the addition is fewer stories, but has a larger floor plate. So this is, again, related to practical difficulties caused by having to meet the historic context, given the designation as a local landmark. On to the 9th variance. There's a standard for the maximum lot area that can allow back-out parking into an alley. So the parking that's on the north side of the site is accessed directly from the alley, and cars either need to nose into the parking spaces and then back out into the alley, or theoretically they could back into the parking spaces. Either way, that's a situation which, as you might imagine, is a good solution in some cases, but not in others. So the code says that, well, if you got enough lot area, you should have to create a parking lot where you actually, where you do your turning around in the parking lot, because you got enough lot area. So that's where this standard comes from. In order to have backup parking, the maximum allowed lot area is 20,000 square feet. What's proposed is a lot area of 37,450 square feet, give or take, with backup parking. In this case, though, we don't have room anywhere on the site to create a new parking lot, because the proposed site plan uses significant portions of the available lot to preserve the particular established streetscape with the sloping lawn and trees in front of the core building. So the parking lot, it would not be desirable for the parking lot to be located there. There's less room. There are fewer places where the parking could be located. And this, in the northwest corner, is the best available choice, which involves backup parking. So the third criterion for this one, practical difficulty, is found in the topography peculiar to the site. The northwest corner, including the portion 20 feet from the west front building wall, which was the first variance. It's the only location on the site that can be made flat enough and close enough in height to the building floor level to accommodate the accessible parking. The practical difficulty is related to the feasible grade of the site, as well as the feasible grade of the adjacent alley. Based on all that, the department recommends that the board adopt the proposed findings and approve the requested variances with the following conditions. Note in the staff report it said with the following condition and then listed two. Obviously it should be following conditions plural. First, the project shall earn the affordable housing incentive established in the UDO as demonstrated in an approved site plan. Staff does not anticipate that this will be difficult for the petitioner because that's the whole point of this project, is providing affordable housing. And second, the variances related to the distance from the right-of-way are valid for the existing distances and are valid for those distances that will occur once the property has been subdivided, just to take care of any uncertainty about where exactly the line will be. Thank you.
Thank you. At this point, is the petitioner here? Come forward. I'll ask your name, and then I will swear you in. Give me your name, please.
Todd Rotman.
Do you affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
You have up to 20 minutes. That you do not use. If you heard because you were in the chambers, you can use later.
Great, thank you. Todd Rotman with Rotman Collier Architects. On this project, we are teamed up with Spring Point Architects, the Bloomington Housing Authority, Brinshore Development, Centerstone, and Bledsoe, Riggert, Coopert, and James as the civil engineers. Our team was awarded this adaptive reuse of the core building through the city's RFI process back in 2021. Our project will contain 38 units of affordable housing. It will be 100% affordable housing. We will also have 10% of those be fully accessible, so there'll be 4 units that are fully accessible, which is the reason for the accessible parking spaces that were mentioned by staff. Since 2021, we have been working with the city through various meetings and communications. There are First Street improvements that are happening. There's the new Jackson Street that's going to be happening. And there was the necessity to determine where our north property line would be and how that would interact with the proposed alley to the north, as well as the property that eventually will be developed north of that alley as well. So this site plan has come about through multiple iterations and changes and coordination with the city to get to this point. Staff did a great job going through the variances and the different reasonings behind them. So I'll just kind of reiterate the point that these variances are basically a result of the existing conditions of the core building as it sits today and the site. And we want to be respectful and cohesive in our design of the new building in relationship to the historic core building. One clarification or modification I do want to make on variance number 1, it was mentioned that our parking would be 3 feet behind the west face of the building on Jackson Street. It's actually 0 feet. I think the 3 feet is, off of the property line. If you look at this site plan, that's not something that has changed. I think it was just kind of a typo. But it's 0 feet. Our parking lines up with the west face of the building. That's it for our presentation, and gladly answer any questions when the time comes.
Thank you. And then for Autumn's sake, I know that you mentioned this is your first meeting. I do want to just stress that for a variance, what we are looking at is an approval of a variance based on peculiar conditions, which means essentially there's something about the particular site that we're looking at that does allow us to grant a variance. That's kind of it in a core. I hope I've summarized that clearly. So with that, we will go to the board for any questions of the petitioner or the staff. And Autumn, do you have any questions?
Yeah, so may I ask, has the project already been, for the affordable housing, which is a broad statement in Bloomington, Indiana, has that been approved? Like, are they able to build this first? So that's already been approved, correct? Or that's part of what we're doing, approving this entire project?
Right. So in order for us to apply for affordable housing tax credits, we have to have all variances in place as well as any design approvals. So last week we received HPC approval of the project. Tonight we're seeking the variance approvals, and then our submittal for the tax credits for the affordable housing will occur in June.
Can I add to that a little bit? Sorry.
Yeah, go ahead, sir.
So that is exactly correct. After funding, we anticipate a petition or a filing for minor site plan review, which is a staff level review. It's non-discretionary, meaning that if they meet all the standards in the UDO, which so far they, well, I mean, with variances, so far they will, then we must approve the site plan. So there is a stage of site plan approval after this, which is anticipated to occur after funding, but that will be non-discretionary. In other words, if they meet the standards, they get the site plan approval.
I think it's also appropriate to say, because of the way you worded the question on it, we're not approving the plan. We're only being asked as to whether we'll grant the variance as part of that plan. I just want to say that because of the way the question was presented.
Okay.
That
you.
I believe is under planning's purview, not our. We're not looking at the entire site plan.
Okay, thank you.
Sure,
Thank you.
yeah. Any other questions?
Yes, can you review the variance number 3, please?
Yes. I think maybe I can show the floor plans. So the third one we gave, number 3, is that in the TRO multifamily dwellings, that ground floor units cannot be located in the first 20 feet of. So actually, on the slide, I cut out a little bit. Let's find the full text of the standard is. For structures with frontage along a street identified in the transportation plan as a main street, shared street, or general urban, and structures along the B-line trail, each dwelling unit located on the ground floor should be located at least 20 feet behind each building facade facing the public street or B-line trail. So I skipped over the point that this only applies to Rogers Street because it's the only one that is, it's general urban. And First Street and the proposed Jackson Street, First Street is and Jackson Street will be neighborhood, is it called neighborhood connector, I think? Anyway, it will not be general urban, so this standard doesn't apply to those streets. So it's just from Rogers Street. And if you look on the, let's see, does my mouse show up here? On the right side, this is the east facing Rogers Street. We've got a unit here, we've got a unit here. These are both within the first 20 feet of the building. Strict application of the UDO would say you can't have these units here, and that space would be lost to the proposed affordable housing use. It could be something else, possibly, but it would cause practical difficulties for the use of the property, given the whole context. Is that helpful? Is there more questions you have about it?
Yeah, I just wanted to know, why are we giving the variance on that when we require other buildings to not have living space, 20 feet from the street? So that's why.
So that gets to what's the justification for it?
Yes, correct.
Ultimately, that's for the board to determine. Staff's recommended finding is that the practical difficulty is found in the existing width of the core building and the width of the proposed addition, which is meant to match. If you took away 20 feet, there wouldn't be much left. And in addition, the constraints on the site make this use as all residential, even without the UDO requirements. There's just practical difficulties with using the building, and so this is. You want to jump in? Okay. Yeah. So this what's proposed is trying to make the best out of the practical difficulties that are there, but the design sort of has to pick its poison about what variances it requests or what, how it gets around. So this is one of the things where, in order to make this happen, those have to be residential units, and so it cannot meet the strict application of the UDO. So the proposed finding, there will not be enough room for any ground floor dwelling units if the standard were strictly applied. Effectively losing one entire floor for residential use would result in the entire project becoming infeasible, is the proposed finding for that criterion for that variance.
Just to add to that, Jackie Scanlon, Development Services Manager. So when we've discussed this for other sites, and as Joe mentioned earlier, we don't set precedent with these, but when we've discussed it for other sites, one of the things we're looking for is interaction with the pedestrian realm. And this building is so far set back from Rogers that you're not going to have that interaction no matter what is on this first floor. So I think the characteristics of the site as is, they can't do an addition on the front to bring the building closer to Rogers because of the historic nature of the building. And so the commercial use in the building, because of the state of how the building actually is physically, would be difficult to do because of when it was built and its characteristics. So the actual state of the site and building lend toward residential, and the things that we normally come to you and discuss related to that commercial or non-residential units in the first 20 feet aren't going to happen here either way because of how far back the building is from the right-of-way of Rogers. So we think it is appropriate to support the variance. Does that make sense?
Yeah, can I see an elevation? Because
Sure.
It sounds like the elevation is part of the practical difficulty, correct?
I think the photograph of the actual to show the height of it.
Because those are stylized.
Yeah. So the way the UDO and the overlay district are set up, our facade is supposed to be between 0 and 15 feet away from the property line, which basically pushes it up against the property line. And I think this provision for residential units being 20 foot back was a privacy issue. They don't want residences right up against the sidewalk where strangers are going to walk by and look in. Well, we're 92 feet off the property line, so that's really not an issue here. We're also 16 feet up above the street. So both of those items are unique to this site that allow for that privacy of those first floor residences.
And that's what I wanted to see.
Yeah.
Okay, thank you.
Any other questions? All right, seeing none, then we'll go to the public. If there's anyone in the public wishing to add comment, we'll do so at this time. Is there anyone in chambers? Is there anyone online? If you'd raise your hand.
There is an individual.
I see, it looks like one has shown up here. Do they have, you have the ability for them to speak, yes?
Yes.
Okay,
Can you hear me?
Yes, can I have your name, please?
My name is Peter Levavi. I'm an
Peter,
executive vice president.
Peter, hold on, please. Do you affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
You have
I
5
do.
minutes.
Thank you. I just wanted to clarify one point about the financing of this affordable housing development. We're the co-developer with the Bloomington Housing Authority, and we brought this project through the State Housing Finance Agency, IHCDA's special program 2 years ago to put special needs housing integrated into an affordable housing development. And as a result of passing through this program and successfully graduating from the program, IHCDA has guaranteed that if we make a successful application, they will smile widely upon it. And they're very much looking forward to receiving this application in June so that they can award this project. They are very aware of the project, and it's going to be something that's very important to the state of Indiana, and they're looking forward to financing it. And I just also wanted to say that the city of Bloomington has been wonderful to work with at every step of the way of this really important project. It's a very difficult project, and we're looking forward to getting it started as soon as we get the financing lined up. Thank you very much.
Question for the staff. Was this person a part of the development group?
My understanding is yes.
Okay, so just for the record, that amount of time is actually devoted to the petitioner. This is a time for public comment, not the petitioner's comment. Is there anyone from the public who would like to make comment, please? All right, that note up there is not a person, right? Very good, thank you. And no one in the chambers, okay. So thank you for that. Now, we simply are counting that last comment as part of the petitioner's time. It's back to you. If you have any further comments, the rest of your time is available to you, which is about, what, 17 minutes, 18? Yeah, about 16 minutes, thank you. You don't have to use it all, it's not a requirement.
Off and I've used up my time, and I learned that doesn't work to my benefit, so.
Yeah. Okay, thank you. We're back to the board for action. And what I'll do is I'll go ahead and put forward a motion just to start. I will move the approval of V-09-23, adopting the proposed findings and approve the requested variances with the following condition: the project shall earn the affordable housing incentive established in UDO section 24.04.110C as demonstrated in an approved site plan. And 2, the variance related to distance from the right-of-way are valid for the existing distances, as well as those distances that will occur once the property has been subdivided. Do I have a second?
A second.
We have a motion and a second. It's time for discussion. If there are any questions, procedural or further statements from the board, now is the time.
I'll just real quick, I just want to really commend everybody behind this, all the groups involved. I live in the Broadview neighborhood, so just kind of south of here. I go by this building every day. I love the idea of, even though, as Autumn mentioned, what is affordable these days? We know that's a fluctuating thing. I think being able to see this in action, where at the Planning Commission last month, we saw a group getting ready to put up an 8-story up on North Walnut with a $1.4 million contribution in lieu towards the affordable housing. While I was supportive of that, and I think that's fantastic, I think being able to see an entire building, especially in what Hopewell is going to become as a cornerstone, it's exciting, and I am very much in supportive of this, and I'm glad to see it here finally. So, thank you.
Are there any other questions or comments from the board?
If the board will allow, I'd like to make a short little comment about the distance for the variance 1.
It's not necessary unless we have a question for you.
Sounds good to me.
Thank you. All right. Do we have any questions or comments again from the board? If not, someone can call the question. Okay, in that case, call for the vote, please.
Throckmorton.
Again, let me just stress, a yes is to approve the variance with the conditions noted in the motion.
Throckmorton.
Yes.
Ballard.
Yes.
Burrell.
Yes.
And McCoy.
Yes.
Very good. V-09-23 is approved. Thank you for your time. And thank everyone for the comments. We now will move on. Before we move on, we're going to take a very short break, 5 minutes only. We'll be back here at 5 minutes before the hour bathroom break, since we've been at it for over 2 hours. Thank you. We are reconvening. We're going to pick it up with Administrative Appeal AA-12-23, which is requesting the appeal of the staff issuance of a notice of violation. May I have a staff report, please?
Yes, thank you. Again, this is a case or a petition from Leo Pilikowski for a property at 2028 East First Street. The petitioner has filed an administrative appeal of the staff issuance of a notice of violation. So briefly, as we've kind of gone through a lot of these basics previously, this is for a property that received a building permit to construct a new house. And as part of that, there were improvements that were required along the High Street frontage, specifically the sidewalk and street trees that were mentioned previously. During the course of our daily activities, we noticed that the building had been fully constructed, had been occupied, but the improvements along High Street had not been installed. So we reached out to the building department to find out if an occupancy permit had been given. We found out that it had, and we told the building department that we had an issue with the site, that there was a site improvement that was required with the construction of the new house that had not been implemented. The building department reached out to the petitioner and told them that. The petitioner contacted me and said, hey, I received information from the building department that there might be a possible violation on the property and wanted to find out some information. I informed the petitioner via email that yes, we would be issuing him a formal notice of violation soon regarding the occupancy of the house and the lack of a sidewalk that had been installed along High Street. The petitioner immediately filed an appeal, even though we had not formally issued the notice of violation. So about 2 weeks later or so, we did issue the formal notice of violation on March 10th. But the petitioner believes that his filing of the appeal prevented us from issuing him a notice of violation. Specifically, there's a section of the UDO referenced on the screen here in regarding a stay of proceedings. And it says that an appeal stays all proceedings from further action unless the planning and transportation director determines that a stay would create adverse impacts to the health, safety, or welfare of the city or neighborhood. So the city asserts that the formal issue of the notice of violation was not a proceedings. The purpose of this section of the code was to state that fines are not accruing from the time period that an appeal is filed to when definitive action is taken on that appeal. It does not prevent us from issuing a formal notice of violation regarding any violations on the property. So that is staff's position, that the appeal that was filed does not prevent us from formally issuing a notice of violation on the property. And with that, I'm happy to answer any questions.
Thank you. At this point, will the petitioner come forward? And I will restate for the record that the petitioner has been sworn in. You have 20 minutes. And again, I will remind you that whatever time you don't use now, before we vote, you will have another opportunity to use the rest of the time.
Thank you. I have slides again, and I'd like you to put up the first slide if you don't mind. My name is Leo Pilikowski. I'm the owner of the property at 2028 East First Street. The evidence submitted that's in the record for AA 823, I'd like that to be part of the record for this appeal. as well as these slides and some notes that I gave to Ms. Scanlon, and that was the same request I made earlier. Okay? This is an appeal of the notice of violation, not appeal of the UDO violations at all, but the process for the notice of violation. Okay? The notice of violation was issued after an appeal of the administrative determination that was of an administrative determination made, I believe, on February 17th of this year, before any notice of appeal. It was an email telling me, was essentially email giving me the interpretation, the determination that I had been asking for 2 years. Okay, I needed a determination to carry the thing further. I finally got that after 2 years. Many, many emails. You see 80 pages of that I've submitted in the evidence, 65 pages of email things that I've tried really hard to do this. So finally got that, and I was told in that email that they were going to start the process for notice of violation. And you can see from the first one, if you go to the bottom, you'll see the date that I did this on. The date is 2/20/2023. Okay? This is 18 days prior to the 10th when the appeal was done, and 21 days, 3 weeks, before the appeal was received by mail by me at 2 addresses. Now, I contend there's 2 issues here. I contend that the appeal, the notice of violation, is a proceeding, and it cannot be issued once I file an appeal. An appeal stays all proceedings. The second point, which Eric Groves did not mention, and that I did mention in my petition, is that I cannot have a violation of the certificate of zoning compliance because I was never provided that. I was provided no access to that in any way, shape, or form. I was provided no notice that there even existed a certificate of zoning compliance. And I will explain more than that again. Now, the petition that I filed really gives all the details. If you've read the petition, it gives the details of how I discovered that there was the certificate of violation, certificate of zoning compliance, how I checked to see if I had one, how I finally found one. I asked the city, actually, Ms. Burrell, I don't know if she's related to you, but she's the one who handed the notice of mailed in. I asked her to send me one. I emailed me one. I didn't get one. I finally got one through the building department after it was found, and I'll explain that. Okay? So I've appealed those 2 points. First of all, I want to talk about the stay of proceedings. Let me make sure I've done the slides right. Okay? If you could do the second slide, I'd appreciate it now. Okay. The second slide actually says about the law and the UDO. And the first thing I want to make clear is that there's a definition of how to define things in the UDO. And they say terms not defined herein shall have the meanings customarily assigned to them in common ordinary language, except that legal or technical terms shall be interpreted in the legal or technical sense. Rogaist, I claim that the notice of violation process is a proceeding. And if you look back, I have copied on this page 29, the administrative manual, which is the rules for the BZA. And I haven't given anything, but it says notice of violation, then it says purpose, and it says process. And the process is the second thing that explains how it's done. Rogaist thesaurus, and all thesaurus, make as synonyms the word proceeding is a synonym for the word process, and process is a synonym for the word proceeding. If we want to do legal aspects, a legal proceeding is defined as a process in the legal dictionaries. So there is no question that the process of doing the notice of violation, which is quite an involved process. There has to be meetings with the staff. And there's actually 3 steps, and I'll explain it later, they didn't even get done in my case, okay, have to be followed. So I don't think there's any question that the notice of violation process is a proceeding. Now, this part of the UDO, which says that says that a stay of all proceedings when I file a case with the BZA is also a matter of state law, and that state law does apply to the BZA because it's how the BZA works, the Board of Zoning Appeals. So there's no question that I should not have been issued a notice of violation. In fact, I tried very hard for 2 years to start to resolve this issue in front of the BZA before there was a notice of violation. So there was time to bring this forward if I needed to take it to the circuit court, if I needed to take it further, time to resolve this issue. The city waited until the last minute to give me an appealable decision. Mr. Roker did give me what the city's point was going to be last July and then in February of this year, but his emails to me were distinctly, by his own statement, not appealable because they weren't done by planning staff. They weren't an appealable order. So I tried really hard. I was really worried about the fines accruing while this whole process started. In emails to Eric Groker, I said, we have to solve this problem, this thing during the construction process, before they need occupancy. And they did not, that didn't happen. So that's why I immediately filed an appeal of notice of violation. I immediately filed appeal of the determination, and then I have a filed appeal now of the notice of violation because I don't want those fines to accrue while this matter gets settled. Okay? Because the fines are $105,000 a week, nearly $1 million a month, $5 million a year. If you go through the courts, this process will probably take about a year to get a final decision out of the circuit court. I just don't want them. So that's my reasoning. I'm not trying to say, but the terms are quite clear. Appeal just stops everything. And if you take a look at the language that they had before, and let me see if I have that here. I don't have the language that was in the, I apologize, I don't have the language about the stay of proceedings that we talked about. Let me make a quick, no, I don't have that language. But you'll notice that there was more to it than just the stay of proceedings. It said that there wouldn't be a stay of proceedings if there was something that was hazardous to health. The city is claiming that the stay is only of the fines. Well, having the fines or not having fines is not hazardous to health. So the stay of proceedings applies to things other than fines because it applies to things that to stop the stay, to not have a stay for those things that are hazardous to the health and welfare of the community. And that was in there. And I apologize for not having that in front of that one. I don't know why I didn't have that. So therefore, I'm asking the board to declare that the notice of violation should not have been issued because it violated the stay in the UDO. Now, the second thing I want to talk about is the certificate of zoning compliance. I did not receive it. Now, I have a copy. I think the next slide should have Eric Groch's email in it. I'm hoping it does. I'm hoping I didn't screw up and do that. Yes, it did. No, it didn't. I apologize. Oh, okay. I'm sorry. That was in an earlier slide before. I apologize. Let me get that email. I'm very sorry that I... Misty Deckard's. You know, I'm sorry. I didn't include that email. You'll have to trust me that I didn't, that I'm telling the truth on this. Oh, yes, I'm sorry. It's the last slide. I apologize. I got them out of order. Excuse me for doing that. Okay. Eric said that the city does not typically send the CDZ to applicants. Instead, they send it to the county. In this particular situation for this whole building permit, the county, we've had a problem with the county. The site plan was not, when I submitted the building plan, the site plan didn't get submitted back to the city. Although I had sent a copy of that site plan to Eric Gurist as soon as I applied for the building permit with the site plan. I did send him one. But the city never answered and approved the plan, and after 3 weeks, I finally said to Eric, why don't you guys approve it? It usually takes less than this. We never got the site plan. So I was in Wisconsin, he said, send me the site plan and also put it up on make sure it gets on the county. The county made a mistake and didn't send it to the city. They didn't send the whole thing. I did send it to Eric. So we know the county makes mistakes, okay? It turns out that the city did send the certificate of zoning compliance to the county, and that certificate of zoning compliance, a scan of that, did get entered into the county permit database, the whole cloud database. However, two things did not happen. At the time, the county was not doing paper stuff. It was all paperless. So that when you had to go in person to pay for your building permit, they gave you two things. They gave you the orange building permit, and they gave you a receipt. They did not give you anything else. If we'll go back to the second slide, I have an email from Misty Deckard, who handled the issue at that time. Excuse me, the third slide. I apologize for that. Okay, you'll see that they said it was paperless, and they just told people to go look on their website if there's any approvals or anything else they needed to see on the permit website. I will tell you, I religiously looked at that permit website because I was handling the permit for my contractor. I applied for the permit and I handled all the details. They called for the inspections, but I handled all the paperwork. Okay. I did deal with Mrs. Deckard directly. She did not hand me a paper copy of that thing, and she said it wasn't the problem. So, but she told me to look in the website for it. I looked in the website. I looked in the website to see all was there. It was not there. She didn't say look for this. She didn't say there was a certificate of zoning compliance. She said look for anything else you need to have, any approvals that might be. I looked, it wasn't there at all. I continued to look for things like that. So I never saw this certificate of zoning compliance. Number two, when I finally got told there was one, and Eric's email said there was one, I wanted to see it. So the next day, which was the 14th, at about 9:20 in the morning, I called up building department planning. I talked to, Mrs. Deckard was no longer working there. I talked to some other lady, okay? I said, I can't find this. Can we look for it? She looked for it, and she couldn't find it. She said, let me look somewhere else. I think she went and looked in the paper file, okay? And then later on, she came back, and she said, look in your attachments now. And I said, I've got my attachments up on my web page. She said, well, refresh it. I'm a little cleverer than that. I opened the new page up. What did I see on the new page? As an attachment, the certificate of zoning compliance was there. I made printouts of those two web pages. Copies of them are here. Can we go up to, the next one, please? Okay, this is the one. Can we go to the bottom of the page? You'll see that this says one story. This is the building permit, one story, and it says add an attachment. It comes at the end. So it would be listed here. Go to the next page, please. You see that it's not listed at all. If you look at the date on the top, at the time I made the screen printout, when I saw the change, it was 9:26 a.m. And I'm very careful about this because I was really concerned about what happened. I made this printout at 9:28 on that day. Okay, so this one does not show the certificate of zoning compliance. Can we go up now 2 more pages? No, back, I'm sorry, to the end, 2 more pages. 2 more pages further on in the thing. The next page, please. Go to the bottom of that page. Go to the next page. Fine. Bingo. On my second open, there's the certificate of zoning compliance. Okay? What happened? I cannot tell you what happened. Okay? I can only surmise that one of 2 things happened. Either it was previously put to a different building permit and the lady put it to this permit, which I don't think is what happened. I think that once she accessed the database, knowing the date, and saw that that had been downloaded, that it was finally linked to my account. Until March of that thing, I could not see that, and none of the inspectors could see that. We could not see that on the website. So I never saw it. Now, Eric Gurlich is saying that, hey, I knew all those conditions. Well, I think we should take a look at the certificate of zoning compliance, and I think it's in the file in front of you. I'm hoping it's in your handout, because it's very important. There are two conditions. It's a conditional certificate of compliance. There's two conditions. Okay? One condition is that I have to seed the yard and stabilize it. The UDO in the other case, and let me see if I have this here. Okay, 5 minutes. Okay. I have to do an and. The code says I have to do or, mulch or seed. That's the 6th one. The 7th one says that I can't occupy the building until the sidewalk is built. But since I thought the city was going to occupy it, build it, that's my contention, why would I agree to that? Had I seen that certificate of zoning compliance in July of 2021, I would have immediately appealed it and stopped all this thing, got everything I wanted, got an appealable determination immediately. But I didn't do it. And if the city really thought I got this, they should have said by 5 days are up, I can't appeal the thing anymore. That was 2 years ago. So I should not be held for a violation of the certificate of zoning compliance. So what I'm going to ask in this case is that the board find that the notice of violation was issued after the appeal was done, the stay was there, and the notice of violation is invalid. And number 2, that for the purposes of any other future violation, I cannot be held to have violated the certificate of zoning compliance when I built and occupied the property because I never saw it. Now, if the city wants the applicants to send them, everything they send to the building safety to be sent to the planning department, the city should reciprocate and send to the applicant a copy of that, of all that they send to the building safety, especially when we knew in this time that there was a problem. So that's why I'm asking for those 2 findings, and I'd appreciate your concern. Just one quick thing. I've tried to do this for 2 years. I'm venting now. I've tried to do this for 2 years. And I had to get a notice of violation to be able to do it. Even though the city knew of the issues with the building department, instead of contacting me directly when they thought there was a notice violation, they had the building department. Instead of contacting me directly with their certificate, they sent it to the building department when they know there's problems. Okay? They have my email, they have my phone number, they can contact me. Why not contact me directly? And in the process for the notice of violation, there's usually 3 steps: a written warning, a written notice, and a written for fines. All 3 of those were combined in 1 letter for me. Now, they can do that, but that's not the usual practice, and that's not the steps in the process. They were all contained at the same time. And then they started the fines the day after the hearing that we were going to have last month. Okay? Which, and the NOVs are supposed to mention in the process that there's a variance. You apply for a variance. They never mentioned that in those, although I knew that. So I'm sorry about the venting, but not getting this thing, if I would have had that 2 years ago, we would not be here tonight. This whole matter would be solved. Thank you very much.
May I ask how much time the petitioner has left?
2 minutes, 11 seconds.
Okay, so I just want to alert you that when you do come back, we'll have to be tight on that timing, okay?
Thank you very much. I realize that.
We will have questions for you as well, so just hang out there. All right, so with that, we'll go to questions from the board to the staff or petitioner, and I just want to reiterate again that this is a request to appeal the issuing of the notice of violation. So that's what we're discussing now. Any questions from the board? And we'll ask Autumn just to be sure since she's online. Any questions, Autumn?
Well, was there a mistake on the side of the city? I mean, was there, look at all these papers and documents and timeline stamps. We all have error. Was there misfiling? Was things maybe not sent appropriately? Is that even an appropriate question? Because it seems to be his biggest concern is that he wasn't notified in an appropriate timeline for his issue. So could there have been a mistake on the city side?
Is that question to the city staff?
Yeah, it would be to the city staff, not to him. He already says there is one.
Very good.
So I guess, Eric, that would be your question.
Yep, thank you very much. So every year, the handling of building permits is something that is outlined. Well, I guess let me back up a little bit. So when people apply for a building permit within the city of Bloomington, they apply to the Monroe County Building Department. The Monroe County Building Department takes in those permits, and then they ultimately issue those permits once they receive a certificate of zoning compliance from the city planning department for the projects within the city. So we have an interlocal agreement that is signed every year between city and county officials that outline this arrangement of the building department takes in the permits. We review and administer a certificate of zoning compliance, and then that certificate of zoning compliance is given back to the county, and the county is supposed to transcribe any conditions on our CZC onto the building permit. So we complied with all of our requirements. We reviewed the building permit. I issued this certificate of zoning compliance to the building department. And so we completed everything on our end in terms of our legal requirements.
Okay, so did the county?
So that I can't say.
So you did what you were supposed to do, but if the county didn't do what they were supposed to do, then it doesn't work together, right? Because if you're giving things, you said you gave your stuff to the county, then the county comes back, correct? So you both have to work in tandem, correct?
Correct. So we work in tandem. So as Mr. Pilichowski pointed out in the email, the condition of approval on the certificate of zoning compliance was simply reiterating the same thing that was shown on his site plan, that a sidewalk is required and a tree plot is required along High Street. This was not a new condition.
Okay.
This was already.
So he knew what he had to do. He already knew what he had to do.
Yes.
He's just arguing the timeline of when this was sent and that was sent, but he already had the knowledge of what needed to be done.
I can't attest to his knowledge, but he did have that information.
The information. Okay. All right. Thank you. That's what I needed to know. Thank you.
Thank you. Any other questions from the board to either the petitioner or the staff?
I question for the staff. In terms of the process, was the process of the notice of violation, did you follow the steps that he said? So did he receive a notice that he was going to receive a notice? Was there, was there time in between different steps before he received the formal notice of violation?
I can speak to that, and Eric can correct me if I'm wrong. He had been communicating with Mr. Grulich informally, and as they both have said, was told that an NOV would be coming, and then an NOV was issued. So the NOV wasn't, you have to build, and it's in your packet, but for the record, it wasn't, you have to build this sidewalk by X date. It was, you need to provide us a timeline for review of when you're planning to come into compliance by X date, by March 24th. So, the timeline could have said, I'm planning to do it in 5 years, and we would have said, okay, let's keep talking about it. We needed to move forward with what is your plan here? It was not, as he mentioned, oftentimes we issue a warning and then an NOV and then a fine letter. But in this case, we just issued one letter combining those, which we do in some cases, especially if, in this case, as you can tell, there was a lot of previous communication with Mr. Grulich about the situation here at this site, so we felt that the petitioner was pretty knowledgeable about what was happening.
My other question is, are there fines being accrued as we speak, or are the fines stopped because we are under appeal? And he talks about very high fines. I wanted to know how that all works.
So our typical practice is that if an appeal, if we have said that we will start fines on a certain date, but you have contacted the department to work toward a resolution, then we do not accrue fines during that time. We can go back and accrue fines. We don't really even have to tell, as long as we know you're in violation, we can issue a fine for you on those days. But the practice of the department is much more, we work with people much more, even on sites, large sites that accrue large fines. Once compliance is met, because that's our final goal, we always bump them down. I would say, I'll use the word always. We just, the goal isn't to, amass a large fine and collect, it's to find compliance with the UDO. So no, we are not accruing fines right now. We could, but we aren't, because that's not the practice we do. And then we would discuss fines at the end if we felt that was still appropriate. If compliance is met, sometimes we don't even end up issuing fines, even if they were discussed.
Thank you.
Any other questions? Okay, seeing none at the moment, again, the board will still have opportunity for comments or questions. Anyone in the public? I see none in the chambers. Anyone online who would like to make comment?
There are no members of the public online.
With that, we will return to the petitioner with just under 3 minutes. You have an opportunity here to make your final comments.
I'd like to make one comment concerning the mistake that I think was made is I think due process and the UDO requires the city to send me the certificate of zoning compliance as well as the county. If I'm the applicant, there's no question that I should get it, okay? If the county is the applicant, the UDO clearly requires that there's conditions for the certificate, conditions for anything, that the person that conditions affects be given the conditions, not verbally, but the written conditions. The 7th written condition here is different. It's extremely different. It says that I cannot occupy the property prior to the installation of the sidewalk. Okay? If I think the city has to install the sidewalk, and I've been arguing that, why would I agree to that? I would not, and I would have appealed it. Had I known it, I would have appealed it. Okay? I don't think that I actually think the fault is partly the city, partly the county. There was a mistake in the county that they didn't get in my file correctly. Obviously, the building inspectors didn't see it because they issued the occupancy permit, and I moved in. The mistake with the city was just not having the courtesy to send it to the applicant. Oh, we just always send it to the building department. That's wrong. It costs no money and no time to make me a copy. When they send it to the building department, CC applicant. I believe the due process requires that. I think the city lost the case. The Underwood case recently, that you can't have a third party do your due process notices. The city should do it. So that's where I am. And I did not know about this one. If I had known about this one, I would have appealed it to the court to you immediately. That's 6th command. It is different than what's in the UDO. That's my opinion, and that's why I would have appealed it. Thank you for the time.
Thank you. With that, we're back to the board for action. We'll take a motion or a comment. I do want to ask one question to the petitioner, though, yes. if I may.
Yes, I'm fine. Thank you. I'm sorry.
It's okay. You're fine.
I want to get done. I want to start the last one.
I understand. You mentioned that the fault lied partly with the county, partly with the city. Would you agree or disagree with the statement that there's fault with the petitioner in that you provided a site plan that said you were going to build a sidewalk and plant the trees, and you didn't?
I didn't say I would build a sidewalk on the site plan. I said details to be determined. I showed the site plan, as Eric said, show it, and we'll work out everything later on, okay? And with the trees, I clearly stated on the plan what I wanted to do about the trees. I mean, the plan clearly stated those things, okay? So if you're going to claim I misled people with that site plan, I didn't, because every time that something was on that site plan, I also explained it in emails that I've given, okay? So I don't think there's no fault about not following the site plan. I think I have followed the site plan.
Thank you.
Okay.
Thank you.
But the fault with respect to the certificate of zoning compliance.
No.
Okay,
You've
fine.
answered my question.
You asked that. Okay.
Yeah,
fine.
thank you. Any other questions before I entertain a motion? If there are no other questions, I will entertain a motion. And if a motion is to come, again, it would be either to approve the appeal or to deny the appeal.
I'll make a motion regarding AA-12-33 for a denial of the administrative appeal.
Do I have a second?
Second.
I second it.
Okay, I have a motion and a second. Is there any further discussion on this from the board? In Autumn, I'll just ask you for a verbal, please. Yes or no? Do you have any additional questions or comments?
No, I don't.
Okay. Seeing none in the chambers, we'll take a vote, please. Again, a yes is to deny.
Ballard.
Yes.
Burrell.
Yes.
McCoy.
Yes.
Throckmorton.
Yes. The administrative appeal has been denied. We shall move immediately to the variance. It's variance V-13-23. May I have a staff report, please?
Thank you. So again, this is a request from Leo Pilichowski for a property at 2028 East First Street. So this petition is a request for a determinate sidewalk variance for the sidewalk requirements along High Street. So I will forego, I guess, kind of the location information. I think we're familiar with where this is. So just for overall view, again, to remind everybody kind of the situation. So the location is on the southwest corner of First and High Street. It is surrounded by single-family residences. Immediately to the northeast of this, you have several schools and churches. So this property is along High Street. And with the petition that was submitted for the site plan approval for the building permit, the petitioner showed the required sidewalk along High Street. And so this was brought about by the construction of the new house on here and fulfillment with the requirements of the UDO that deal with when sidewalks are required. So real briefly for the history of those of you, the requirements for sidewalks with the construction of new single-family houses is something that has been discussed and revised and altered many, many, many times over the years. And so the language that we have in the current zoning code for the Unified Development Ordinance is very specific. And it says that sidewalks are not required on existing legal lots of record on non-classified local streets, and if there are not sidewalks on the adjacent properties. So this property has frontage on both First Street and High Street. High Street has a functional classification of primary collector, so it is not exempt from being required to install a sidewalk. But First Street is a non-classified local street, so it is not required to have a sidewalk, even though there is one already present there. So the presence of the sidewalk on First Street, as well as the frontage on High Street, with High Street being a classified street, requires a sidewalk along High Street. So, as we have gone through the history of modifying the Unified Development Ordinance and looked at the situations for when we want sidewalks to be installed, we certainly saw lots of situations previously when sidewalks were required for new construction of single-family houses in every instance. And so it resulted in a lot of situations where you just had an individualized segment of sidewalk on a local street that really was feeling like it wasn't accomplishing a lot of the goals of the community for getting sidewalks installed in situations where it was very unlikely that it was going to be heavily used or that further improvements along a corridor might be possible or probable to get those installed. So we significantly narrowed the scope of when sidewalks are required, and requiring sidewalks on classified streets was one of the main triggers for when a sidewalk is required. So this is important because, the classified streets are the more heavily traveled streets within Bloomington. These are streets that have higher traffic volume, higher pedestrian volume. In fact, High Street along this location here has well over 5,000 average daily trips. So there are a lot of cars that move along High Street. So the presence of sidewalks provides obviously safety improvements for pedestrians. You know, pedestrians will walk along corridors regardless of whether or not there are sidewalks. So installing sidewalks along streets always improves the safety for pedestrians. The presence of sidewalks and street trees also serves to slow vehicle speeds. This is something that has been demonstrated in a lot of studies, is that the presence of these sidewalks and street trees does slow traffic speeds, which also equates to pedestrian safety. So having these sidewalks and getting them in when they're required is extremely essential, and is why the UDO has been tailored and designed to require them in only very specific situations for single-family residences. So with this, you know, as I mentioned in the previous discussions, the petitioner showed the required sidewalk along High Street with the approved site plan and the tree plot. You know, as we've mentioned several times, some of the specifics of the tree plot width and the location of the sidewalk, you know, we had left open to work out with the petitioner at the time that the sidewalk would be installed. You know, in the situation of having to keep certain street trees that were on the property previously. You know, as we've kind of mentioned and discussed, you know, a lot of those trees have been removed and there were only 2 trees at the end. But again, you know, we're still happy to work with the petitioner on the sidewalk location, you know, to preserve any existing trees and to stub it to a property to the south at a situation that makes the most sense. So with variance criteria, you know, there are 3 criteria that we have to make positive findings for. You know, the first is that the approval will not be injurious to the public health, safety, morals, and general welfare. And this is something that I touched on earlier with the basic requirement of sidewalks. So, you know, what we are here today as part of this variance process is not to question the logic for when sidewalks are required. That was already handled with the city council and the plan commission hearings that came up with this language. So they've already said, the policy and the law has already been said, when you construct a single family house on a classified road, you build a sidewalk. This is a situation that we want this. For all the reasons that I mentioned, for volume, for pedestrian safety, lower traffic speeds. And so the granting of this variance will be injurious because it will further those goals that I previously mentioned. You know, it will force pedestrians to walk in the street, to walk on the grass. And this property has almost 200 feet of frontage along High Street. So this is a significant stretch of road to be able to install, you know, sidewalks on. In addition, you know, this is almost immediately adjacent to several schools. You know, this is on a route to school that people will be walking. So that places an even higher need for a sidewalk along this corridor to provide safe transportation opportunities for people walking to areas within this vicinity. So the second criteria, that the use and value of the area adjacent to the property will not be substantially impacted. We did not really find that there were any necessary conflicts with this. Certainly if the sidewalk is connected and extended further south, then that will help complete the system along this corridor as well. But we didn't immediately find any you know, criteria that negated that one. The third one, and this is the criteria that we deal with the most. It's the hardest and really is, you know, should be one of the main bases of a variance, is that the strict application of the terms of the UDO will result in practical difficulties in the use of the property. So, you know, what this is saying is requiring this thing will prevent this property from being used in a manner for which it's zoned. So in this case here, why does the installation of a sidewalk prevent this property from being used with a single family residence? So it doesn't, you know, whether the sidewalk is there or not, you know, the lack of the sidewalk there doesn't prevent them from using this house and living there. You know, the second part of this is that the practical difficulties are peculiar to the property in question. So what is it about this property that is unique, you know, that does not allow the petitioner to install a sidewalk? So you can see on the site photo here, there are no environmental constraints. There are no steep slopes. There are no sinkholes. There are no physical impediments. There's nothing unique about this frontage that prevents the petitioner from installing the sidewalk. And so, that is the fundamental basis of a variance is there has to be something unique about a property that doesn't allow you to meet code. And so this is where we just do not find any findings for this third criteria. We've stated that we will work with the owner to locate the facility in a manner that is consistent with the corridor to preserve existing trees, to stub it to the south, but we do not find any practical difficulties associated with the use of the property for a single-family residence. There are properties all over Bloomington with single-family residences with sidewalks in the front, and they work and they function just the same. So the installation of a sidewalk will not affect the use of this property or present any practical difficulties in the use of the property. So with that, we do recommend that the Board of Zoning Appeals adopt the proposed findings and recommends denial of the variance. And with that, I'm happy to answer any questions.
Thank you.
After the petitioner.
Thank you. It's to the petitioner, please. Again, I'll restate for the record that he is already sworn in, and you have 20 minutes.
My name is Leo Pilichowski. I reside and own the property at 2028 East First Street, and I have slides for this too. The vast majority of my neighbors wanted to be here tonight to support this variance, and I asked them not to come, mainly because a variance is not a popularity contest. I know that. It's making findings on the requirements of the law. But more importantly, I wanted them to go to the meeting for the High Street Corridor MUP to see what was going on. And I do have some information about that from my wife that may or may not be applicable in this case. That attendance, that meeting was very important because that is the process, the plans for what's going to happen in that corridor. The staff report recommended denial of the variance. Okay. Tonight, I've been made to look like the bad guy because I've argued with things, but I've misled people maybe on my site plan and whatnot. I don't think I have. But let me say this. I realize that this board here does not set precedences on their variances. I've realized that for a long time. I was chairman of the Planning Commission in Tucson. I know these things. But the staff reports and the staff recommendations should be consistent throughout the process over reasonable periods of time. The staff report recommended denial of this variance in part because the petitioners requested a determined sidewalk variance to not require any pedestrian facility along a high street frontage. I'm not doing that. I'm asking for determinate variance, okay? So that at the time that it's appropriate to do a sidewalk on that section of High Street, and I think it's appropriate when they will do the whole block, the city can ask me to do that, or we can handle and have a sidewalk. So I'm not asking for no sidewalk, just let me have it. I'm asking for a delay for this sidewalk until we have the study and until we're going to do that, the correct systematic sidewalk for that. In this case, the staff's pointed out at the proposed finding 2, they've agreed that that's a finding that can be done. The sidewalk on my frontage is, they're talking about the sidewalk on the frontage would need to be, when you do a connection between the streets, that's the time to build it. That's what they talked about in their finding, for their proposed finding number 2. Then the portion of the sidewalk will be installed to complete the system at a later time. So that's a positive finding that needs to be made, and that's what they've recommended. But the other 2 findings that they haven't remade. There's already a sidewalk on the east side of South High Street on the same block. So therefore, at this time, there's really no adverse effect of not installing the sidewalk. It's not going to make the situation any worse, me not installing this sidewalk. It's going to stay the same as it was. I think the adverse effect is having a sidewalk that ends in the middle of the block. So it may be safer to walk on a sidewalk, but right now no one walks on that area, okay, no one walks on that area. It's unsafe to get people in the middle of the block with a false promise that the sidewalk's going to continue and have them go in the street, especially children. So putting the stub sidewalk there is adverse and worse condition than we have right now. I understand how people think they want partial sidewalks because it helps, and we're going to do this system along. And that's an argument that's made in the legislative bodies all the time. It's my belief that they should be systematically done correctly. If you go into that street, you jaywalk, or you walk with your back to traffic, those are both illegal actions under the Indiana Code pedestrian laws. I'm worried about the attractive nuisance of that. So therefore, I think that putting the sidewalk there makes it more adverse, makes the situation worse than it is now, because it's a busy street, okay? And whatnot. So I think that that's something we have to look at. Of course, the property presents no topological issues. It's flat, it's easy to do. But for the third criteria, that there are practical considerations and conditions particular to my site, you just don't look at the topological situation. You get to look at 4 other ones that they have listed in the staff report: B, C, D, and E. And notice you don't have to meet them all. You only have to meet, if the board wishes to grant that variance, they only have to meet 1 of those. I think they meet 4 of them. That the pedestrian traffic reasonably anticipated over the street in which the new construction is erected is not and will not be as such to require sidewalks provided for the safety of pedestrians. There's no more traffic here. There's no traffic extra than we already have. The adjacent lots to the north and south, and in fact, all of the single-family lots to just south of 2nd Street to Steer Park on the west side of the street have no sidewalk. Nearly a mile. The 2 above conditions I talk about are true. And they'll be true until the proposed MUP or corridor site is planned and implemented. The Mayor and Council plans to implement it. At that time, the MUP will handle increased traffic and any other pedestrian facilities, and there will be pedestrian facilities built on the west side. That's part of the plan, well, that's what part of the plan that was told me, but they haven't decided that yet. They'll include a continuous sidewalk between First and Maxwell, which is what I want to do my part of the sidewalk. So you could find those 2 findings. D, the location of the track is such that a complete pedestrian network is present on the other side of the street in the same block. That's true. There's a sidewalk on the other side, on the east side of High Street, that people take now, okay? No one walks on okay, I can't say no one. Very few people walk on the other side. More people are gonna walk if they get to see the sidewalk and walk in the middle. So that finding can be made too, okay? But in addition, there's the Clifton side path, which is 300 feet to the west. That provides, and it was built particularly for the school children south of 1st Street, to get those children up to 1st Street to a new sidewalk that was built in the mid-90s on the north side of the street so they could get to cross 2nd Street and get to the Rogers Binford School Complex. Specifically built instead of the sidewalk on 1st Street to do this. So we have a complete pedestrian network in that area already. The kicker, uniformity of the development of the area would best be served by deferring sidewalk construction on the latter track until some future date. Yes, in this particular case, we're studying the MUP. It's currently in progress. It's received the first and highest priority for funding from the City Council. It is best to wait for a unified plan before installing the sub-sidewalk. In addition, the strict application here today will result in practical difficulties requiring the sidewalk to be installed without a plan for the corridor as a whole and could result in the city having to remove the sidewalk in the future. These practical difficulties are particular to the property because the property is located along an area where the city has not yet been able to design the desired alternative transportation system. The granting of the determinate variance will allow the city the opportunity to devise a plan for the corridor as a whole and can require the sidewalk to be installed at a future date after study is done. I have proposed findings up here. On the first, let me make sure I've got the right number of pages here. On 2 pages here, I've proposed findings, okay, to meet the, and I'm not going to read them all off, but it's not injurious to the health because there's already a sidewalk on the east side of because there's a sidewalk on the east side of High Street, and the mid-block stub will attract people to walk on it, and will, if it's only that stub, it will be more dangerous than not having it. The city has already said that the use and value of the adjacent property is not adversely affected. They're not 7% because there's no sidewalks already there. And if we implement the corridor plan, we're going to get we'll probably get a sidewalk between First and Maxwell. The strict application was the one they've done. Strict application, I've said the strict application will result in practical difficulties because require sidewalk to install without a plan for the corridor as a whole, may result in the city having to remove the sidewalk in the future, and I've explained that already. I'm also going to do the B, the pedestrian traffic anticipated is less, and C, I've explained that, and D, the location of the lot or tract is such that a complete pedestrian network is already present on the same block on the other side of the street, and it's actually even more present 300 feet to the west in the Clifton side path. And the uniformity of development is best because we're studying the corridor, we're going to wait for it to be done. Now, you may think that you may be familiar with, and I'm sure the city is familiar with, those proposed findings. Those are the city's proposed findings in 2015 for 930 South High Street, which is 550 feet south of mine. It's a new property that was built, completed around 2018 or 2019. Those findings for a site on High Street, mid-block sidewalk, okay? The only difference between my sidewalk and the sidewalk on that site was I have a school nearby, and that sidewalk doesn't connect to a perpendicular sidewalk on another street. But all the other findings, and in particular, the finding that it was peculiar to that site was that there was a sidewalk on the other side of the street. So in that particular case, the staff recommended an approval. In my particular case, the staff recommends a denial. That's an inconsistency that I see. The staff can do that. I'm just pointing that out. I think in this particular case, to wait until there's a corridor plan and to make sure that we have a complete sidewalk between First Street and Maxwell is the best optimum solution for the city. The stub sidewalk goes nowhere. It won't be used. It may have to be removed in the future. If a bike lane is put on the west side, that sidewalk would have to be removed because the bike lane would take, the street is only 22 feet wide. Travel lanes now, they'll have to take another 9 or 10 feet of right-of-way to do that. If a sidewalk is put on that side or an MUP, they'll also have, MUP especially, have to take more sidewalk. So something's going to be done in the future. There's no reason to do it now. So I'm asking just to delay this until we know what's going on. I'm sorry to waste your time about this, but I really think this, if we can't do the other two, this is the best temporary solution right now, okay? And I will cooperate when that corridor goes. I've talked to my neighbors, a lot of people don't like it. I think it's a good idea, and I support it, and I will do what I need to do to support it with my property and with what else, okay? If it's done, I think it's a good idea. And in fact, let me just tell you, when I was in Tucson as the chairman of the Planning Commission, my nickname was Mr. Curbs, Sidewalks, and Alleys, because I always wanted curbs, sidewalks, and alleys in the developments that we approved. So I know that's a little facetious to tell you that you know, people come to you and say, oh, I support this, but I want a variance from it. I support this, but I want to. I just want to delay this until we can get a complete systematic sidewalk, and especially one between First and Maxwell. Once we do that, we can solve the wall problem because the city will do that with my neighbor, and we'll solve lots of the problems. So I thank you for your time, and I'm hoping you can give me consideration of this variance. This variance solves a lot of the problems, and gets rid of a lot of sticky stuff here, and there's going to be a sidewalk in the future. It's just it'll be the correct sidewalk.
Thank you. How much time does the petitioner have?
6.5 minutes.
Okay, very good. Now, at this point, we're back to the board for any questions to either the staff or to the petitioner about the request for variance from the sidewalk requirements.
I have a question for the staff.
Yes, please.
And my question is, can you explain the determinate variance for a sidewalk requirement in terms of time limits and how it works? Thank you.
Mr. Grulich, you want to do that?
Yeah, so a determinate variance just simply says that a sidewalk is not required at this exact moment when the UDO would typically require it. So there is a zoning commitment that is recorded that goes with the property so that future owners know that this determinate variance has been approved and that the city can call it in and require a sidewalk to be installed, essentially at any time in the future. So there's not a time limit, it goes on forever. I'll just say that, I'll just leave it at that.
Once the property is
Yes.
sold.
It goes with the property.
So if the property changes ownership, it goes with the property?
Yes. I'll just point out, some real world complexities of, a property changes owners and somebody else comes in and we call them and say, hey, you've got to put in a sidewalk. They're gonna say, we have no idea what you're talking about. That makes it much more difficult. We've always found, and the reason for the requirement when there's new construction is that's when things are happening. Money has been apportioned for certain things. You've got construction equipment and workers on a site. It's easier to get things installed when you've got new construction happening than trying to get it installed at a later time. But the determinate variance, provides us the opportunity to still require that legally at a future time.
Briefly with a point of order, I do want to remind the board that the board's rules indicate that adjournment happens at 9 p.m. for all petitions. So you would just stop this petition at 9 p.m. and we'd all go home. Unless the board wanted to vote to suspend the rule that adjournment happens at 9 p.m., that vote would have to be unanimous and everybody would have to agree to extend the board's meeting beyond.
Right,
9
and the
p.m.
complexity to that is this clock is running slow. So I kept looking at the clock, but I look at my watch now, I see that we only have 5 minutes
It is
left.
8:55, yes.
And so thank you for bringing that to my attention because I thought we could be done by 9, according to that clock, which is not accurate. So at this point, this is a procedural issue. Can I have if it's desired, I will take a motion to extend through the end of this petition.
And again, I'm sorry, I just want to remind the board, this vote has to be unanimous.
Yeah, 100%. And then the idea here is if we don't, we would finish our hearing in 4 minutes and have to come back and complete it next month. So I would just need a motion so that we could vote as to whether we want to extend it through the end of this petition.
I make a motion to extend our time beyond 9 p.m. tonight to finish this motion. This
a second,
petition.
please?
Second.
Second, okay. And again, it needs to be unanimous for us to continue. Please call the roll, please.
Yes.
Burrell,
Yes.
McCoy,
Yes.
Throckmorton.
Yes. And as on the record, I'm not going to believe that clock as we move forward. Okay. So with that said, we're still at the point where the board is asking questions of the staff or of the petitioner. Do we have any further questions?
I have a question. So I'm to understand that there's not been a specific date given to the petitioner as to when he has to have this sidewalk completed?
So that was something that was addressed in our notice of violation, is that we were requesting a schedule from him of when this would be installed.
But you've not given him a date as to when it should be installed?
No, that was something that the notice of violation was trying to initiate that conversation to get it into compliance. So, as I think we've said, we're willing to be flexible on, when that is going to need to be done by. We certainly understand and recognize that there is a process right now to engage the adjacent residents to determine and discuss a corridor improvement project along here. From indications and conversations with staff, we hope to be able to have some decision on that within the next month or so. We hope to have that kind of direction on that very soon.
So could it make sense to hold off on the sidewalk till you have that completed? Would that be something that would be understandable?
Well, so certainly, we are understanding of this process that's going forward currently, and we are happy to be flexible. I don't want to speak completely out of turn, but I believe that we're happy to be flexible to let this process play out, to see what the implications of that are for the corridor and the petitioner, and then continue to work with the petitioner to come up with a timeline, whether to install the improvement or, to work with the city if there is a city project that would involve something on his property.
Okay. So it makes sense to see what the city has decided to do with the corridor, correct? To understand that project?
Yeah, so what I'm saying is from a staff level.
Okay.
So what is before the board tonight is whether or not you want to grant a determinate variance. And what I'm saying is, we're still happy to work with them, even if the variance is denied, to work with him on, a timeline in keeping with the city's plans for community involvement.
Correct. Okay, thank you.
So just to put a fine point on it, Eric, if we were to deny the variance, what I'm hearing you say is the staff would then still be cognizant of these ongoing discussions about that corridor and would work to see which direction it's going, whether the city's going to put it in or not. And then at that point, you would then make a reasonable decision about moving the homeowner towards finishing the sidewalk that was promised. Is that what I'm hearing from you?
Yes.
Okay.
I would obviously want to confirm that with our director and my manager, but
I understand, yes. But essentially, to go off of what Autumn was saying, what we're really talking about is we can still say, no, we don't want to provide a variance, okay, so that it is on the record that sidewalk is still necessary. If the city down the line chooses to build it, great. But if they don't, the homeowner is still required to do what the UDO calls for.
Correct.
The statement I've made is correct.
Yes.
Thank you.
So I do have a question. So if we approve the determinate sidewalk, if we approve the variance, do we have the same end result?
Not necessarily, because we don't know if the project goes forward on High Street, we don't know yet whether or not the city will build it on the west side or the east side. So they had their public meeting tonight, I think the first one, to gauge, to get input from members of the public. Letters were sent to property owners along the potential route. And then ultimately, engineering, in conjunction with the administration, will, if they go forward with the project, will decide which side to build it on. So if you issue a determinate sidewalk variance and they decide to build it on Mr. Pilichowski's side, then when that project goes through, which won't be for years, the process takes a long time, then we could call the determinate sidewalk variance and Mr. Pilichowski would be responsible for the funding of his portion. But if they decide to build, if you issue the variance and they decide to build it on the east side, then there isn't a trigger there. And we think that this portion of sidewalk is valuable enough that he should have to build it whether or not it's a connection to the south or not. So, and I mean, I can go into why again if you want, but
No.
yeah, so that's why it's different.
Yeah, no, thank you.
Any further questions before we go to the public?
Just one quick to Eric. I think for clarification purposes, I think when the question was raised about does this carry over if the property transfers ownership, you're basically saying that that's attached to the property, but there's no way to enforce that really legally to be done? Or
no, it is still attached and it's legally enforceable on future owners. I was trying to say that, from a perception standpoint, it can be harder, if we're dealing with two owners down the line, for a house that was built 10 years ago and, now we're trying to get them to cough with the money for a sidewalk when, the petitioner, as part of the building a house, already had that into the budget. It's easier to get that accomplished when a house is being constructed than, 2 or 3 owners down the line. But we can always require that. It's always legally enforceable.
Okay, so if the ownership transferred, they would have to disclose something. I guess what I'm getting to is, right, denying this to me, making sure it's guaranteed to be done versus putting it off, it transfers ownership. Then if it's not disclosed, that potentially comes on somebody. I'm not saying that would happen, but that could come on a new homeowner by surprise, and they would have to still put the sidewalk in, correct?
Correct. So hopefully, they do their due diligence and do their deed research and they discover the zoning commitment. But yes, that is, somewhat of a hazard.
Okay, thank you.
Any additional questions before we go to the public for comment? Is there anyone on Zoom who would like to make a public comment?
There are no members of the public on Zoom.
Thank you. Anyone in the chambers? Seeing none. With that, we will go to the petitioner for final comments. 6.5 minutes remain.
I would much prefer a determinate variance, because then we put this off until the city, the end result is the same. The city, if I've determined variance, the city can call in the marker. There's no question about that. I would hope they'd call in the marker. I get the feeling they're not going to, when we can have a complete sidewalk. In fact, I will tell you, the amount of time I've spent on this, it'd be cheaper for me to build the sidewalk myself all the way from First to Maxwell. But I can't, because there's other people's property involved in it. And there's a lot of complications involved in it, okay? And it's also not right away, not in front of my property. And it takes a city, it's not easy to do. But it would have been a lot cheaper for me in time and money just to do that than to go through this mess. The cities, I've been told that no matter where they put the MUP, there'll be a sidewalk on the west side in the future. The city wants to do that. I've also been told tonight that one side, the MUP, there will also be a bike lane on High Street. They're going to take another 9 or 10 feet of right-of-way. Any sidewalk that's built now on the east side, and that's where they might want to put the bike lane, will have to be taken off, okay, if it's in the right-of-way. The determinate variance gives us the time to wait on this. In addition, the determinate variance is recorded, it's a legal recorded document when the property's sold. And I'm not going to sell that property until I die, okay? It's my last house. I hope I got 20 years left. I'm 74, probably don't have 20 years left. It's a ranch, ADA compatible. We built it to live in the rest of our time, okay? But it's recorded. They'll see it in the title report. They'll have to sign off on it. It will be in the title report that that's a restriction, okay? There's no doubt about that. And the price of the property will be, sale price will be reflected in that. If people, what a reasonable, confident buyer and realtor if they look at that. So I'd rather have that done. The time scale for this project is not going to be a month. You won't know in a month what's going on. The first starting meetings are beginning right now, and they're just beginning. The right-of-way acquisition will not begin until 2024. And until you can do the right-of-way acquisition, you're really not going to know a lot of what's going to be going on because you don't know what property you can obtain. Really quickly to tell you, between Maxwell and South Downs, the city does not own the High Street. It has a presumptive easements for the travel lanes, but if you'll notice when you drive down there, a couple lawyers have walls going all the way out to the travel lane because they want to keep that property as their own. So the determinate variance, although it has the same final effect, the sidewalk will get built and I will be responsible, is a more flexible for me and safer for me. And I think in general, it's better than having an agreement with the city. We don't know what the city is going to do. We'll make a decision in a month and whatnot. This gives me a determinate variance. It gives me some legal means to say, hey, I don't have to build it right now. So I'd ask you to do that determinate variance. And those findings that I've given are findings that have been used in the past. They're quite reasonable findings, okay? And as I say, that stub sidewalk is not, with the school kids there, is not safe. It's safer to have no sidewalk than to have the stub sidewalk. And it's safer to have a complete sidewalk between First and Maxwell, which is what my neighbors would like to have, which is what I would like to have. So I do ask you to do that for me, and I thank you very much for your time again.
We are back to the board for action, or we'll take either a motion or additional discussion before a motion is put forward. Anything? And I'll just, before a motion is made, I'll just say that this doesn't seem to warrant the need for a granting of a variance because that complicates things. The sidewalk by the UDO needs to go there, and granting a variance is just going to complicate it and make it a little more muddy than it needs to be. The staff has been pretty clear that should the city decide to build on that side, that they're going to work with the homeowner. My opinion is that, just let the homeowner understand that no variance of any kind is given, that the sidewalk must go in per the site plan. Make that really clear, and then let the city and the homeowner work out in the terms of the timeline. That's my opinion before a motion's made. Any other comments or questions? If not, then I will take a motion.
I'll make a motion for V-13-23 in denial of the determinate variance from sidewalk requirements.
Do I have a second? I'll second. We have a motion and a second in front of the board. Do we have any further discussion from the board?
I just want to add what kind of you said already, but I think just having finality to this, for you, if I can speak to you, frankly, you've put so much time and effort and energy and probably money into the last couple of years of doing this. And while I applaud you for your cause and what you're fighting for, because we all have those things, I just feel like this needs to be finalized, and this is the best way to do it. And that way everybody can move forward with this. And if the city, and we've had these before, and we've made determinations before, and the city and the city planners, their willingness to work with individual property owners, we know that happens. So I think we can probably give some assurance to that as well, that what Mr. Grulich is saying is, you put it in. If we have to put it in, we're going to work with you if the corridor does end up happening. And that'll be my reason for supporting the denial.
Are there any other comments before we call the question? Autumn?
No, I have nothing more to say.
Thank you. Hearing that, again, a vote of yes is to deny the request for the variance. Will you please call the roll?
Burrell.
Yes.
McCoy.
Yes.
Throckmorton.
Yes.
Ballard.
Yes.
The motion passes. The request for variance has been denied. Seeing no other business before this board, I call for an adjournment. Thank you.